Today's class we are trying to, as I've said, that we are trying to come up with something new, that is most important topics that I want to cover from the last second's point of view. I know your exams are around and you're waiting for which topics to concentrate, which not to concentrate. So I've taken like the top 10. It can be even a small topic. It need not be a complete section. Inside a section, it can be just one paragraph, which I feel is more important. So I've tried to put all those particular topics, like 10 to 11 topics from every chapter, and I've tried to frame something like this. So I'll try to see what best I can do. I thought instead of just sharing it would be good also to say in that part which one to concentrate, which one not to concentrate. So I'll try to keep this session as short as possible, because if I do it for 9-10 hours, it will become one marathon only. So I'll touch these topics as much as required. On the face of it, I will just brush through. So if you guys have already watched marathons, people, and one more thing, because we wanted to do this, we did not do a marathon again this time. Whatever was premium was the previous one, and it is absolutely very much relevant. People remember, law remains the same 99.99%. Some additions might have happened, which we will be covering tomorrow, that in RTP, or else the rest will remain the same. Probably yes, one or two amendments might be there might be a change, but rest of it will be the same, nothing will change. So you can feel free to watch it. Yeah. So, but yes, because what is there, people, when that particular content is already there, and if I do the same thing again, I don't think it makes sense to do it every 3 months, and the content would have been the same, right? So I thought, why not a different approach for the same content? I thought this was good. So remember, this is a quick revision of the most important topics. This is based upon the most asked questions in the past and probable questions that may come in the future. And I might have left certain topics that which you might have studied, because if I take up everything, there might be something which is important I might have not considered it, and it is absolutely fine. You guys can give a quick read. In addition to whatever you guys are seeing, make sure you are also seeing these things. Clear, all of you? Okay, done. So let us start, people. The first one is your associate company. Now, what do you mean by associate company, people? Associate company, to keep it quick, a company which is a company in relation to another company, means a company in which other company has a significant influence. So one company has a significant influence in another company. Significant influence means what, people? Minimum 20% up to 50% is called as an associate company. An associate company includes a joint venture as well. Okay. Financial year. What is the financial year? Why did I include this? Because remember, in financial year, two things are important. If at all a company has a date of incorporation as 31st December 2025, its financial year ends on 31st March 2026. If a company has its financial year starting on 2020, 1st Jan 2025, then its financial year will end on 31st March 2027. So this is one thing that is 25, 26. So 25. So it will not be, sorry, this is not 27, it will be 26. Correct? That is, it will not end, this would become 24, 25. So it would not end in 25 only, so it become 26. Correct? So that is one thing that I wanted to tell you. It is important, remember and go. Next one, government company. It is important. What is government company? A company in which central government or state government, or central government and state government, or state governments holds 51% of paid up share capital will be called as what, people? Government company. And a government company's subsidiary company will also be deemed to be a government company. Remember that. So government company is also important. And remember, there can be any other way they can ask you. There can be a company A where say government company holds, so they can give you an example like this. LIC holds 20% in company A, and central government is a majority shareholder in LIC. Let us imagine something like this, 51%. and state government is holding 10% in A, and central government is holding 31% in company A. Now the question is company A considered as a is it considered as a government company? The answer is no, because this LIC holding part you should never include, because it is nowhere included in the definition. No, definition says only central government, central and state governments. Nowhere it is written that government company holding some share in another company and that company holding some share should also be added. Only thing is, if it is directly 51%, yes, it's a deemed subsidiary company. So it will become a deemed government company. But this way it will not satisfy the limit. So remember this. This is important. They may ask you a question. The next one, people, listed company. What is a listed company? Important. They may ask you a question. Very, very possible question from the MCQs point of view. Listed company is a company which is listed, which has listed its securities on a stock exchange. However, the following companies will not be included in the definition of listed company. What are that? The listed companies who have listed their non-convertible debt, meaning I'm talking about non-convertible debentures issued on private placement basis. Both are important. It should be a non-convertible debt and private placement basis. And next one, non-convertible redeemable preference share issued on a private placement basis, meaning non-convertible. But remember, you can never issue a irredeemable preference share. It has to be redeemable. So people, non-convertible redeemable preference share issued on a private placement basis. So imagine if non-convertible debt is issued on a public basis, public issue, then it will become a listed company. That's the meaning of it, correct? So these two companies, if they have listed their non-convertible debt on private placement, non-convertible redeemable preference share on private placement basis, such companies are not called as listed companies. So whatever is there in this particular chapter will not apply to them. Next one, private companies which have listed their non-convertible debt securities on a private placement basis cannot be considered as listed company. Remember, this is also important. Yes, some preference shares they cannot list because there is a restriction as per the definition. Public companies which have listed their equity shares on a recognized stock exchange, that is as per a jurisdiction mentioned in section 23.3. What is given in 23.3? 23.3 is nothing but people of foreign jurisdiction. So anything that is not in India, but if you are listing your equity in such place, then people, you will not be considered as a listed company. Remember that. The member, who is a member? A person who subscribes his name to the memorandum of association, meaning initial shareholders. Every person who agrees in writing to become a member is also called as a member, meaning what? The company is coming up with a private placement, rights issue. I want to buy the shares, I am considered as member. Third, when every person holding the shares is a beneficial owner. Beneficial owner will come in the case of demat shares. Correct? So they are called as a member. Officer who is in default. Who are the officers in default? In every section you will be seeing that whenever there is a penalty, then these are the people who will be liable. See, why I have said this is important is people, not even once this particular question has been asked. That is about the officer in default. You guys see, I'm not saying not even once, means in the recent times they have not touched this question. So in a company, who will be considered as an officer in default? It means any of the following officers. The first person who is considered as officer in default is whole-time director. Full-time director in a company. Second person who is considered as officer in default, it will be KMP. Third one, where there is no KMP, my company has no KMP, key managerial person. Who is key managerial person? CEO, managing director, whole-time director, manager, CEO, CFO, CS, and one level below the board, and they are designated as KMPs, then they are called as KMPs. So when there is no KMPs, then such director or directors as specified by the board in this behalf, who has or have given his consent in their writing to the board to such specification, or all the directors if no director is so specified. In the act you will be seeing, right, such person authorized by the board. So if a person is authorized by the board, then he will come here. No one is authorized by the board, then people, all the directors will be covered as officers in the default. Next one, any person who under the immediate authority of the board or any KMP is charged with responsibility including maintenance, meaning any person under the board or under the KMP and is in charge and the responsibility has been given to him, such person will be considered as officer in default. Any person in accordance with whose advice, directions, or instruction the board of directors of the company is accustomed to act. other than a person who gives advice to the board in professional capacity. This is very, very important. They can pick your question here. Meaning what, sir? Imagine people at times, a company would be listening to whatever the other company says. Now say for example, if you guys watch Shark Tank, one person invests, say for example, a very big influential investor, he invests just 2% in a company shares, but the company will listen to whatever this person says, because for them this person is important. Whatever he says, that business decision, the company will listen to him. So they're telling you even such person will be considered as officer in default. But remember, you are a CA. You will be giving business advices to the company, and accordingly they will also be acting. Should I consider you as also an officer in default? Because according to your control, your advice only, the board is acting. No. So should I consider you as an officer in default? They tell, should I consider? That's what they're telling you. You will not be considered as an officer in default if you are just acting in your professional capacity. That is not considered as control. It is just an advisory role. So you are not considered as officer in default. Next, every director who is aware of such contravention by virtue of the receipt by him of any proceedings of the board participation without objecting to the same, or where such contravention had taken place with his consent or connivance. What is this, sir? Sir, I participated in a board meeting. They asked a particular decision which actually led to that non-compliance. In that board meeting, I voted for the resolution. Then you are liable. Sir, I did not vote at all. You are still liable. Because why did you not stop? You just did not vote. Sir, I said no in the resolution. I tried to stop them. Then you will not be considered as officer in default. Next one. In respect of issue or transfer of any shares of a company, the share transfer agents and registrars and merchant bankers to the issue or transfer, they are considered as officer in default. This is nothing but, people, in the case of companies, wherever we want to register our transfers, there are so many transfer requests that keep happening inside the company. If we are outsourcing it to some other agency, that is registrar and share transfer agencies. So if we have given it to them, they will be considered as officer in default. Clear? Okay. Next, who is a promoter? Important from exam point of view. Before promoter, which else thing will come? Section 2, clause 68. Private company is a company in which by its articles of association restricts its transferability of shares, limits the number of members to 200. Joint shareholders should be counted as one. Past and present employees should not be counted. Prohibits the issue of shares to public. Is called a private company. Public company is a company which is not a private company. A deemed public company, if at all there is a subsidiary of a public company, will be deemed to be a public company. Okay. Next one, people, promoter. Who is a promoter? A person whoever is named as such in the prospectus, meaning in my prospectus, which will be filing in prospectus and allotment of securities, chapter 3. In that chapter, if I'm considered as a promoter, if they have named me as a promoter, I'm a promoter. That's all. Or if I am considered as a promoter in annual return, then I am a promoter. Annual return, section 92, MGT 7 or MGT 7A. In that, if they have put my name or if they have considered me as a promoter, I am a promoter. So remember, promoter is not always a person who starts the company. Remember that. Who has control over the affairs of the company, directly or indirectly, whether as a shareholder, director, or otherwise. Whoever has a control over the company, in our case, the person who holds 2%, in our previous example, is still able to control the entire company. He is considered as promoter. So a person who is a director, who is completely controlling the company, but his shareholding is less, he is also considered as promoter. In accordance with whose advice, directions, or instructions the board of directors of the company are accustomed to act. So this 2% scenario can directly come here. Here at least they have given the shareholder. Here they are telling you, in whose advice all my directors are accustomed to act. Meaning this person says our directors will listen. That person is considered as promoter. But remember, again, same thing. The professional capacity, a CA, CS, CMA, all these people will not be considered as what? Promoters. Because we advise, that's our role. We are not controlling them and all. Remember, important from exam point of view. Remember, KMP we saw, officer in default, private, public, promoter company. What is a small company? A company whose paid up share capital does not exceed, sorry, a company other than public company whose paid up capital shall not exceed 4 crore and whose turnover does not exceed 40 crore as per the preceding financial year. Now, sir, certain companies will not be considered as small company. Which are they? Section 8 company, holding and subsidiary companies and statutory companies will never be considered as small company. One more thing you can add here is people, subsidiary company definition also you can add. A subsidiary company is a company which controls the composition of board of directors. So when one company controls the composition of board of directors of another company, and another company is called a subsidiary company. Next one, if a company holds more than 1/2 of the total voting power in another company, whether on its own or together with its subsidiaries or a deemed subsidiary company, that is, one company holds in another company, what, 51%, another company holds another company 51%, this company will be a deemed subsidiary of company A. That is called subsidiary company, correct? Small company 285, subsidiary company 287. That's your first chapter, important, remember and go. Next one, people, incorporation chapter. OPC, of course, people, the main thing I've written it here is I have uploaded one more video also, people, with regards to resident or otherwise. Yeah, with in-depth clarity I've given. Please watch that. Here what I'm telling you is a OPC always should mandatorily nominate a person, that is nominee. A OPC will always, who can start a OPC, whether a person is, the person has to be an Indian citizen, the person has to be a natural person, and whether the person is resident or otherwise. For a person to be considered as resident, he should have stayed for a period of 120 days in the preceding financial year. Then you will be considered as a a resident. Then you can start a OPC. To become a nominee also same rule. One person can be a member and nominee in not more than one OPC. At the same point of time, I can be a member also, I can be a nominee also. In one OPC and one OPC, it is possible at the same time. Imagine if a place where I'm a nominee, that shareholder dies, that means I'm becoming a member of two OPCs. In such case, within 180 days, I have to leave one OPC, I have to continue in another OPC. A nominee can be changed any given point of time, and even the nominee can also resign. That is also possible. Correct? OPC cannot carry on NBFC activities, and OPC shall mandatorily have OPC in its name. Minimum number of members 1, maximum number of members 1. Done. Section 3A, minimum number of members. What is section 3A, people? It says that a company shall have minimum number of members throughout its life of the company. At any given point of time, the minimum number should not go to what is given in the limit. Private company is 2, public company is 7. If at all this number goes below the prescribed limits, then you have to increase this number within 6 months. Sir, what if I do not increase it within 6 months? Any contracts entered post the 6 months, people, the liability of such continuing members, meaning imagine in a public company, 7 were there, 5 are continuing, 2 left. So whoever in this 5, whoever are cognizant of the fact, meaning aware of the fact, sir, such people who are aware of the fact, people, will be unlimitedly liable, personally liable for the contracts entered post 6 months. MCQ, it's a very, very important question. It is post 6 months. Always remember, unlimited liability starts post 6 months, not during the 6 months. It is post 6 months. And only for those members who are aware of the fact that my number of members are reduced from minimum requirement. Only for them it is. Yes, sir. Next one is people, and one more thing, if you guys are using my book, I've tried to put the page numbers also where these topics are so that it can save your time. And I can't think of anything else more than that. First initially I did not do, but later on I started doing it. So that is there. In the case of incorporation of a company, what is important? Okay, incorporation of a company, this is important. So whenever you file MOA and AOA with ROC, that has to be signed by whoever are the subscribers, meaning the first shareholders. Now what if the first shareholder that person people is illiterate. In such case, who will sign the document? This was, I think, recently asked also. I keep telling this question is important. So if the person is illiterate, he will affix a thumb impression. In addition to that people, one more person which shall be the described as such person writing for him. So one more person should write on behalf of him his name of the subscriber or below the mark and authenticate by it his with own signature, and he shall also write against the name of the subscriber the number of shares taken by him. Meaning what? If I am illiterate, I will affix my thumb impression. Under that people, someone else on behalf of me should write that it is affixed on behalf of Mr. A who has subscribed to 5,000 shares. That has to be written there. Remember that. Where the subscriber is a body corporate, meaning if it's a company, then MOA shall be signed by the directors, officer or employee, whoever is duly authorized by a resolution passed by the board. Meaning in a board meeting we should have authorized someone to go and represent us. That person will go and sign the MOA. In the case of LLP, a partner authorized by the LLP, that person will come and sign. Whereas if a person is a foreign national, then such person people always remember his proof of identity shall be notarized by a notary public, and if such person residing in a country outside the Commonwealth, then always remember apostolization is required. So this we would have seen in the class. Now I will not tell you what is apostolization and all, but remember foreign national, yes, possible. Where the subscriber to MOA is a foreign national and residing outside India, and visited India and intended to incorporate a company, in such case the incorporation shall be allowed if he or she is having a valid business visa. What is the difference between these two? Imagine a foreigner who is staying abroad, from there only he is investing. He has not come to India. In point F, he has come down to India. Now he is staying in India. Then people, we have to mandatorily give the business visa because he is in India. We need to just be sure that this person has a right to stay in India. So considering the business visa, yes, it is possible. Yes, that is one important aspect that you guys have to see. And okay, more or less touch those topics. Doctrines pay more attention. I mean, I'm saying reasonable thing, because wherever there is a simple attempt, there will always be at least 10% of the questions that will be catered to easy questions. Their doctrines can come. So quickly, doctrine of ultra wires going beyond the powers does not bind the company. It will personally bind the directors. Doctrine of constructive notice, whoever is entering into a contract with the company is always assumed to have the knowledge about the company. Indoor management, whatever happens within four walls, the outsiders are not aware of this fact. So it does not bind the outsiders to the company. So always outsiders are protected from the company. That is called doctrine of indoor management. Remember and go. Entrenchment provision, people. In entrenchments, he specifically have given 2.20. Now what is 2.20? Which says if at all you want to entrench articles in the case of public company and in the case of private company, how do you do the entrenchment? Remember, if you are a private company, if you want to do an entrenchment, what is an entrenchment? Making your articles more stricter and stringent than what is given under your Companies Act. Meaning Companies Act says that to alter your MOA, pass special resolution, but my article says no, you have to take 100% approval. That is called entrenchment. You are making the article stricter on your company. Understood? Hello? Okay. So private company, how do I alter? Correct. Yes. How do I alter? People, all the members have to agree. In the case of public company, then I have to alter it by passing a special resolution. Possible MCQ questions, all these are. So remember, in a private company, everyone have to agree. In a public company, special resolution is satisfied. Okay. Rectification of name of company. What is this, people? 2.24. Nothing but whenever a company is existing with a similar name, that is a company similar to already existing name, then what will happen? This provision is similar to your LLP also. What will happen, people? Within 3 years of a second company or a LLP, both together I'm explaining you. There's a company X which was invested first. There is another company invested, it got incorporated next. So company X and company X, this is called phonetically same, so you cannot incorporate. So within 3 years of this company getting registered or a trademark, this company should go and file a case with central government that there is a duplicate company. Central government, if it is satisfied, it will pass a notice and it will give 3 months time for the company X to change its name. As and when you change the name, people, you have to intimate the registrar. Registrar will issue a certificate of incorporation. Failure to register, failure to change the name within 3 months, people, is in such case, central government only will allot a name to the company X. They may change you to company Y, or as the case may be. So they will only allot a new name, and accordingly a certificate of incorporation will be issued. Post that, can a company still change its name? Answer is possible. They can still change the name of the company. It is absolutely possible. Next one, shifting of registered office of the company. How do we do it, people? If it is within the same city, you will just pass a board resolution. If it is from one city to another city, you will pass board plus special resolution, provided if it is in the same state. If it is from one jurisdiction of ROC to another jurisdiction, people, if it is board resolution, special resolution plus RD approval. From one state to another, people, it will be board, special, RD. Technically it is central government, but RD approval only. But you have to make sure, people, no jobs are removed. You have to give a declaration to the chief secretary of the state that I have not removed any person from the job. All the dues are cleared. If all that is satisfied, then yes, people, you can definitely go ahead with shifting of registered office. Okay, copies of memorandum articles to be given to the members. 2.28. Very long time it's been since they have asked this question. That's why I have taken it. Copies of MOA and AOA to be given to the members. If any shareholder requests for a copy of MOA OA, you have to give it. It provides that a copy shall, on payment of the prescribed fees, send a copy of each of the following documents to a member within 7 days of the request being made by him. So if I have asked for a MOA OA, a copy has to be given to him. Whether it can be MOA, AOA, or any agreement that is entered as per section 117. What is 117? Where you have seen MGT 14 will be filed, no appointment of managing director or such scenario, variation of shareholder rights if any happened. I'm just giving an example, that and all will come, no. Any failure will make the company as well as every officer in default liable to a fine of 1000 rupees for each day during which the default continues, or 1 lakh rupees, whichever is lesser. So sir, whatever is the penalty, if at all I am not giving my copy, sir, then this will be the penalty, that the person will be liable for this particular penalty. Clear? Okay. Commencement of business. Again, it's been a long time that they have asked of late. So I took that question. A company incorporated after the commencement of company, a declaration is filed by director within 180 days that every subscriber to MOA has paid the value of the shares agreed to be taken by him on the date of making such declaration. The company has filed registrar a verification of registered office. If any default is made, it's okay, penalty now leave, and the registrar has reasonable cause to believe, he may initiate the action for removal, that is strike off the name. The declaration by a director shall be verified by CA, CS or CMA in practice. In case of company pursuing objects, sectoral regulators such as RBS, as the case may be, such regulator shall also be obtained attached to the declaration. What is that, sir? Nothing but, people, before we initiate our business, start our business after getting incorporated, within 180 days, people, I need to file a form with the ROC that, sir, my shareholders have completely given the money that they promised in the subscribers to MOA. They have told, no, that we are going to buy 100 shares, 500 shares. They have purchased, sir, the money has been given. And sir, we have also given our proper address to the registrar. This has to be declared by the directors. And this declaration has to be certified by CA, CS or CMA in practice, that everything is clear and correct. If that is the case, people, you guys can file certificate of commencement of business. The ROC will give you certificate of commencement of business. You will be filing commencement of business. ROC will give you certificate of commencement of business. After that, people, you can start your production or whatever is the work, you can absolutely start. Clear? Okay, that is one thing I wanted to say. Subsidiary not to hold the shares of the holding company that we know. Company X, company Y. Company X holds 51% in company Y. Company Y, can they hold shares in company X? Not possible. However, this rule has a exception that you can hold as a trustee, you can hold as a legal representative of any deceased person, or you became a shareholder even before you became a subsidiary company. I became a subsidiary company on 1st Jan 2026, but I became a shareholder in company X in say 1st Jan 2025 only. You can continue to hold, but remember the only thing is such subsidiary company shall have a right to vote at a meeting of the holding company only in the respect of shares held by it as a legal representative or a trustee. Meaning what, people, whatever is my direct holding before I became a subsidiary, I had some shares, I had already invested. On those shares, people, I will not have voting rights. They can ask you a question here especially. A long time they have not asked this part at all. So remember, important point. Clear? So trustee, legal representative, and before only I was a subsidiary company. On that before only, I will not enjoy any voting rights. So this is a possible question. Remember. Okay. That is what I was able to make it from here. Next one, sir. Prospectus. All four. What is all four? One is shelf prospectus. One is red herring prospectus. One is deemed prospectus. One is offer for sale. All four are important. So let us see that. What is a shelf prospectus? Offer. If at all a company wants to do an offer in more than one issue, they will file one form called as shelf prospectus. The validity will be 1 year. Using the same prospectus, you can do multiple offers within this 1 year. It's absolutely allowed. Provided whenever you do multiple second offer, third offer, if there is any change in the financial position of the company, if the company has created any new charges and all, that has to be intimated in the information memorandum in form called PAS2. Correct? You need to intimate that in the form called PAS2. Shelf prospectus, people, section 31. And remember, if at all you have received any advance money from any shareholder, you have to give him an opportunity when you are going for a second offer. You should give him an opportunity to withdraw the money. If he is not interested to participate and continue, you should give him an opportunity to withdraw the money. That is shelf prospectus. What is red herring prospectus? A red herring prospectus is nothing but a prospectus in which not the complete details are disclosed. Everything will be there except the quantity or the price per share will not be disclosed. After the entire offer is done, you will again file a complete document with ROC and SEBI. That is called as red herring prospectus, section 32. We generally do it to discover the price. 32, red herring prospectus. Next one is called as, people, which one? Deemed prospectus. In deemed prospectus, the main point is this, people. When will the company be considered as deemed prospectus? This is the main thing. When it be conducted. So, whenever a company A is not directly issuing the shares to public, then company A is giving it to a broker or an underwriter. And the underwriter is further giving it to public. He is further giving it to public. Then they are telling you this may become a prospectus if, people, any of one condition is satisfied. Now what is that, sir? Where is that? No, here. This is the point. What is that, sir? First one. When will the shares given by him to the public, when will it be considered as prospectus? The first one, people, that an offer of the securities for sale to the public was made within 6 months after the allotment or agreement to allot. Company A allotted the shares to an underwriter on 1st June 2026. And this person, underwriter, is further giving that shares to the public within 6 months. 6 months is 30th June. If I am giving it on, say, 1st May 2026, it is within 6 months, then whatever the shares I am giving it to him, it will be considered as public issue. And this document, whatever I use to give it to public, it will be considered as a deemed prospectus. It is condition number 1, within 6 months. Second condition, or any one to be satisfied. On the date when the offer was made, the whole consideration. So I have given to the underwriter 10,000 crore worth shares, and the underwriter is now selling this to the another person. When, let us imagine, we gave the shares to the underwriter on 1st January 2026. The underwriter is selling it to the other person, that is the public. He is selling it on, let us imagine, 1st Jan 2027. That is literally after 1 year. Now, is it considered as prospectus? According to condition 1, no, it is not a prospectus because it is going beyond 6 months. But I have second question. Has this underwriter paid this complete 10,000 crore to company A? Have you paid? If the answer is no, still some money is to be paid. When you are giving the shares to them, to the public, that time if still some money is to be paid to company A out of the 10,000 crore, whether whole or in part, some money is still outstanding, then this will be considered as a deemed prospectus. That's the most important part here, remember. And the last one is considered as offer for sale. What is offer for sale? Whenever the shares are taken from the existing shareholders and it is given to the public, the document through which the shares are given to the public will also be considered as a deemed prospectus. So you have to comply with all the conditions of prospectus. However, minimum allotment will not apply. Minimum application money will not apply. Minimum allotment is nothing but as given in prospectus. Technically, as per SEBI rules, it will be 90%. Minimum allotment should be, meaning minimum subscription. Next one, minimum application money will not apply. According to Companies Act is 5% or anything else prescribed by SEBI. That is prescribed by SEBI is 25%, but not required for us. That minimum application money is also not applicable for OFS, offer for sale. And whatever is the matters stated in prospectus on utilization of the proceeds, whatever you are receiving from the public, what will I utilize this money for? They technically, why will you utilize that? You will take it and you will give it to your existing shareholders. No, they gave the shares. So OFS, why do people do it? Because whenever in a listed company and all, there is a minimum public shareholding concept. At any given point of time, 25% of the overall shares of the company should be in the public, should be with the public. If that number decreases, the promoters will come and sell their shares to the existing public. Recently, Patanjali did it. I hope this is clear and you are able to understand something. Yeah. Okay, next one, people. Variation of shareholder rights. Variation of shareholder rights. Okay. So, sir, the preference shares, sir, I was issuing them 12% interest, sir. Now, I want to increase it to 14%. And the tenure was 4 years. Now, I want to make it 6 years. Is this possible? People, any variation, it is possible, provided you have to call them for a meeting, and if they approve, then we don't have a problem, and that is what is variation of shareholder rights. But remember, whenever a variation results in, if it affects any other class of shareholders, you need to call them as well, you need to take their approval as well. Now, for example, from 12% to 14%, when preference shareholders' dividends are increased to 14%, don't you think the money available to equity shareholders will reduce? So what they are telling you in this scenario is, people, in such cases, I need to make sure I first take a preference shareholders approval as well as equity shareholders approval. If one variation results in another shareholder rights getting affected, I need to take their approval as well. Next one, if at all in preference shareholders, if at all not less than 10% of the people they want to object the scheme, they're free to object. They can go to the tribunal and they can object this particular scheme. Sir, we don't want it, please cancel it. That is possible. Correct? That is variation of shareholder rights. Okay, shelf prospectus, 31. Okay, done. And liabilities for misstatements, always remember. Here, try to remember criminal liability, civil liability. Criminal liability, that is, you can be punished fraud, that is, you can be put in jail also for any misstatement you have done in a prospectus. Civil liability is, we try to recover the money and we will try to give it to a person who has suffered the loss. That is called civil liability. And remember, there is a concept called as class action suit. Class action suit is nothing but people. What is this? Liabilities only for misstatements. Majorly, which one you guys will concentrate? Wait. What is abridged prospectus? Nothing but a prospectus in a summary form. Class action so 37 instead of class action, so try to remember pay more in civil liability. So who will be first liable? Remember, this can be a question where a person has subscribed for securities of a company relying upon any statement included in the prospectus, and if he has suffered any loss or damage, then the company and every person, company is also liable, and every person. Who is every person? Who is the director of the company, who was a director at the time of the issue, they are liable. So whoever has suffered the loss, the directors have to pay the money for them. Next one, a person who has authorized himself to be named in the prospectus as director or has agreed to become a director, meaning a proposed director, will also be liable. If he has authorized to include his name in the company, that is in the prospectus, but he is still coming in as a new director, but he has agreed to add his name in the prospectus, proposed director, he is also liable. Third one, promoter of the company, whomever we saw. Next one, authorized the issue of the prospectus, whoever has authorized the issue of prospectus. Next one, he is an expert referred to in subsection 2, like architect, a professional, a CA, CSO, all these people will come as an expert, then we will be liable. So whatever is the damage they have suffered, we have to pay. But what is the exception? Exception also important, and the other part is also important. That having consented to become a director of the company, he withdrew his consent before the issue of prospectus, and then it was issued without his consent. Meaning what, sir? The moment I got to know that something like this has happened, I have to go, I have to say, you give back my consent, I'm not okay to inclusion of my name in this particular prospectus, and the prospectus should have not yet published yet. That is the case, you'll be excluded. Second one, the prospectus was issued without his knowledge. On becoming aware, forthwith gave a public notice. Meaning what, sir? I am a director, I do not know that the company has gone for an IPO at all. But after I get to know that they have gone for an IPO, immediately I have to come and give it off in the public notice that people, something like this has happened. I have no clue what has happened. I will not be liable for anything. You have to give a public notice. Third one, the misleading statement purported to be made by an expert. Meaning an expert, we are saying no, that you are liable. Expert is nothing but people, a person who is giving a guarantee, authenticating that, sir, buy this share, yeah, patta, sir, next, this is the Diwali, bumper bonanza, this share will go like this, like that. Someone who is authenticating a lot of information, we call such particular person as an expert. He will not be liable. He proves that I had a reasonable ground, that whatever I certified, I have a justification for it. Based on that only I certified. If you can prove that people, then yes, I will not be considered liable. That is important. Okay. Securities to be dealt within stock exchanges 3.15. So there is one main topic of what is the maximum commission you can pay on underwriting. That's the main part you have to focus on. Yeah, payment of commission. Whenever a company goes for an IPO, what is the maximum commission it can pay? It says the payment of such commission shall be authorized in the company's AOA. The commission may be paid out of proceeds of the issue or profit of the company. They can ask you a question here. How can it be paid? The rate of commission shall not exceed, if it is shares you are issuing, 5% of the price of the shares, or if at all your article says something, some other number. If it says 8%, so it's 5 or 8, whichever is lesser. In case of debentures, it is 2.5 or what is given in articles, whichever is lesser. That is important. Remember from this particular point of view. That is what I've given here. Private placement, people. What is a private placement? In a year, what is the maximum number of people to whom we can do a private placement? The maximum we can do is 200. And remember, it is an aggregate in a financial year. What do you mean by an aggregate? I do some private placement in the month of April. I do it in the month of May. I do it in the month of October. I have to add everything in a year. It cannot go beyond 200. And remember, the limit is always per security. They can always ask a question here. Correct? Yes, sir. And in this number, that is this 200, certain people are excluded. And who are those people? One is people, employees. If you have been given ESOP options, do not count them. Next one is qualified institutional buyers, mutual funds, banks and all. Don't include them. Yes, and one more thing, which other? Non-applicability. This section will not apply to NBFCs and HFC companies. You have to pass a special resolution whenever you go for a private placement. But remember, if you are issuing the shares to any QIB, the special resolution will be valid for a period of 1 year. Important, they may ask you. During the year. Offer come application letter, it is PPOL, that is nothing but PAS4. That is the offer letter. You will maintain a complete record of private placement in the form PAS5. Once the private placement is done, you need to file a form called PAS3, return of allotment with ROC. What is the main point? People, this is important. How to buy the private placement, how to participate? It has to be by check, or it has to be via demand draft or any other banking channel. You cannot do it by cash, not allowed. Important, they can ask you a question. Next one, people, this is very, very important. No two private placements can go simultaneously. If one private placement is running, you cannot start another private placement. So no fresh offer or invitation shall be made unless the allotment with respect to the previous one is completed. Again, a question they can ask you. Next one is time limits. Whenever a person, you receive the money, within 60 days of receipt of the money, people, I need to make the allotment. If within 60 days, if I do not allot, within the next 15 days, I need to refund the money. If I do not refund the money within 15 days, I need to pay an interest of 12% per annum after the expiry of the 60th day. So from 61st day, I have to pay at the interest the rate of 12% per annum. Filing returns, we saw. There is one more thing. What is one more thing? One important thing should be there. People, this is also important. The money received on application under this section shall be kept in a separate scheduled bank account and shall not be utilized for any purpose other than allotment or for repayment. Meaning what, people? Before the allotment is done, you are not supposed to utilize that money. They will ask you a question here also. The company, even before the allotment, PAS3 is done, return of allotment is filed, the company started utilizing the money. Is this act of the company valid? Answer is no. Before filing the return of allotment, the only purpose why the company can use that money for is allotment, or people, it can be for the purpose of refund. You cannot utilize the money for your business purpose. Until then, it has to be kept in a separate bank account. Is this clear, all of you? Okay, done. That is your 42. Okay, next, people, share capital, DVR. So DVR is important, people. I'll tell you what is more important here also. I sense a MCQ questions coming more in DVR, which is in 4.2. What is more important? First one, to give a DVR, I'll tell you peculiar points. First one, it has to be authorized in AOA. Next one, it is just an ordinary resolution required whenever you want to issue DVR shares. And remember, what is the next one? The maximum DVR you can issue at any given point of time is your total voting power of the company. In that, the maximum that can be with the DVR shareholders shall not exceed 74% of the total voting power of the company. Next one, this is where the important thing comes. The company should have not defaulted in filing its accounts and returns both for the 3 financial years preceding the date of filing this particular DVR. So my last 3 years, there should not have been any default in AOC4 and MGT7. Next one, financial statements and annual returns, that is for 3 years. No default. The company has no subsisting default in payment of declared dividend. I have declared. Have I paid? Yes, I have paid. If I have not yet paid my declared dividend and if I have made a default, I cannot give DVR. Repayment of deposits, preference shares, interest, debentures on it. Subsisting means what, people? Sir, 2 years back we had made a default, but today it's no longer default because we repaid it last year only. Then okay. When you are issuing DVR, there should not be any existing default. It's not 3 years, 5 years. Today it should not be a default. Okay. Company has not defaulted in payment of dividend on preference shares, repayment of any public financial institution, state financial institution dues with respect to statutory payments, default in crediting to IEPF. Remember, payment of dividend on preference shares and repayment of any term loan from PFIs, dues with respect to statutory payment relating to employees and IEPF. They will ask you questions from these three. That is PFI, state level financial institutions. If you have made any default in paying your employee salaries, provident fund, gratuity fund, or if you have made any default in paying to IEPF, then people remember you should first make good the default. That is, first pay your employees and 5 years cool off period. From the year, end of the year, you have made good the default. Meaning, I have made good the default on 1st November 2025. What is the year end? 31st March 26. From here, you cannot do DVR for 5 years. After the 5 years is done, people, that is, my first year will start from 1st April 26 to 27. So count like this for 5 years. Whenever the financial year ends, after that, beginning of there, you can go for a DVR. Next one, you should not be penalized by any acts during the last 3 years, like people SEBI, FEMA, RBI. All these acts you should not have been penalized in the last 3 years. If you are penalized people, then you cannot go for DVR. And remember, existing shares cannot be converted to DVR. DVR cannot be converted to existing shares. Clear? Okay, that's the main point here. DVR, variation of shareholder rights 4.6, again an important one. What is variation of shareholder rights? Section 47. Voting rights of a member, equity share capital. Every member of a company, limited by shareholder shall have a right to vote on every resolution based on the company. Right to vote on resolution was no repayment of preference dividend. So what is variation of, voting, no. Variation of shareholder rights we already did know, 48. Oh, we did it in section, wait 1 second, there is some mistake. Did we do it in the previous part only? Okay, variation here only we have done. Yeah, we did it here only. The section 48 we have covered there only. But yes, the same thing, consent. Correct? That is 3/4 special resolution, no equity preference, so 10% can go to tribunal, that part. Okay, remember. Sweat equity, calls on shares and all, calls in advance. Can we pay calls in advance? Can we pay dividends and calls in advance? The shareholder who has paid will not be eligible. Remember this. Will not be eligible for any dividends on calls in advance. You can be interest in some cases are allowed, but people, you cannot pay dividend. Voting rights you will have, you will not have voting rights also on calls in advance. Sweat equity shares. What are sweat equity shares, people? Sweat equity shares are nothing but the shares issued to its employees for with or without consideration. Without consideration means consideration other than cash. So if the shareholder, if the employee has given us what is that? It is a asset that he has given, then you can carry it forward to balance sheet. If he has given anything other than asset, that is anything other than depreciable or amortizable asset, then you have to expense it. Correct? Sweat equity. So if a person has given us know-how, making available rights and value addition, people, what is the maximum sweat equity that we can give at any given point of time? Once in a year, it can be 15% of the existing paid up equity share capital or issue value of rupees 5 crore, whichever is higher. That is the maximum I can give in 1 year. Sir, in the lifetime, people, I cannot go beyond 25% of paid up equity capital. If you are a startup, you can go up to 50% of paid up capital up to 10 years. Here it is equity. Here it is equity. Here it is equity. Here it is paid up capital. Remember, open your eyes and see. And lock-in period, people, it can be up to 3 years. It is possible. The sweat equity shares shall be locked in or non-transferable for a period of 3 years from the date of allotment. It shall be for 3 years. Valuation, non-cash consideration. If it is something depreciable or amortizable, carry it to balance sheet. Anything other than that, people, then expense it. They can ask you a question here. Yes, you have to maintain the whole records in form SH3. Remember. Okay, next one, what else? Preference share. What is preference share? The maximum A company cannot issue a irredeemable preference share, but if it's a convertible share, it's okay. The maximum time period of redemption, people, cannot be more than 20 years. If at all it is an infrastructure finance companies, infrastructure companies and all, you can go up to 30 years, provided you need to repay at least 10% at the discretion of the shareholder. You have to repay at least 10% every year, beginning from the 21st year for infrastructure companies. Correct? That is preference share, and they by default they do not have a right to vote, but they enjoy a right to vote if at all there is any matter that any matter where they have a right to be heard. Preference shares winding up and reduction of share capital. In these three cases, preference shareholders will have a right to vote. Okay, and if at all there is a failure to pay a dividend consecutively for 2 years, people, in such cases, the preference shareholders will have a right to vote on all the resolution placed before the meeting. Okay, what else shall be redeemed out of profits, out of the profits of fresh issue? What else? This is important. What is that? If at any given point of time, if the preference shareholders, we are not able to repay them, we are not able to repay immediately, then we can do something called as a rollover. Meaning what, sir? We have to repay a total preference share of 2000 crores and the dividend is 200 crores. So for the total 2200 crores, if we call them for a meeting, if consent of 3/4 holders in value, if they are giving us, and if tribunal approves for it, people, I can issue new preference share in its place. The old preference shares will be assumed as if it is redeemed. Correct? And remember, you will be always given an exit opportunity by the tribunal for those who are not able to agree or consent to this particular resolution. So remember, that is important. Transfer and transmission, all try to remember share certificates. Transfer and transmission, quickly I'll tell you, whenever a transferor signs a transfer deed, transferor and transferee, they sign a deed. It's called transfer deed. This transfer deed should be given to the company, and this has to be given within 60 days of your signing of this particular transfer deed. If it's partly paid share, we will give the transferee, we will check with him, do you know that it's a partly paid share? And this person has to reply to it. Failure to reply will be considered as deemed approval. So remember this one thing. In share certificates, there's a timeline. This try to remember. Within how many days should we issue the share certificates? If it's incorporation, within 2 months I have to give you the share certificate. Share certificate will always be in the form SH1. In case of allotment of shares by a company, within a period of 2 months from the date of allotment. So remember, people, whenever it's a first time or any subsequent allotments, rights issue, private placement, anything, whenever they apply for it, within 2 months I need to give the share certificates. Next one, sir, in the case of transfer and transmission, just now you saw SH4. Within 30 days, that is within 1 month from the date of receipt of the company, the instrument, we gave SH4 to them. No, within 1 month from that, they have to register the transfer. In case of any allotment of debenture, people, we will have 6 months time. Remember, important. Personation and all. Okay. Section 62, important. This is nothing but, people, further issue of capital. We have majorly 3 things there. Technically 4 things if you actually see. One is section 62(1)(a). What is this? It's nothing but a rights issue. Rights issue is nothing but an option given to the existing shareholders. By default, the rights issue will have an option to renounce. What do you mean by renounce? I got a right, because I'm an existing shareholder, I have a right to buy more shares in the company. But because I'm not interested, I can give my right to someone. That someone can be my shareholder or it can be a random outsider also. I can give that to him. That person will apply on my behalf, meaning he will only buy, not for me. He can buy it on his behalf. It is possible. So that is only called as rights issue. By default, a share will always have a right to renounce. By default, you will have. However, a company can restrict it by its articles of association. Remember, that's one peculiar point. It can be restricted in your articles, meaning in our company, there will be no right to renounce. Then it will be no right to renounce. That's point number one. Second one, people, the minimum number of days the rights issue should be open for. Minimum days is 7 days. Maximum days is 30 days. And remember, I cannot give you the letter of offer today, and I cannot say the offer will open from tomorrow. Whenever the offer opens, we should have at least given you 3 days prior notice. If it is opening today, you should have given me the offer at least 3 days prior. Sir, and can we follow lesser timeline, sir? Yes, possible. In case of a private company, if 90% of the members give their consent, the period lesser than above shall apply. Meaning what? You can follow even 1 day also, minimum offer period. Today you can give an offer period and you can say tomorrow is the last day. That is also possible. In a private company, it will be good. It's valid. Yes, sir. They can ask you a question here. Remember and go. Next one, sir, ESOP. ESOP, what is the main thing in ESOP? The main thing in ESOP is, people, that the definition of employee will be the main thing. What is the definition of employee in ESOP? If you guys remember, the definition of employee will be a permanent employee who has been working in India or outside India. A person who is working in India or outside India, and the person can be a director also. It is allowed. Can we give ESOP to a director? Yes, people, possible. Whether he is a whole-time director or not, we can still give it to him. But remember, we cannot give it to an independent director. They can ask you a question here. They have not asked this, but it is a possible question. You cannot give this particular ESOP to your independent directors. And to whom else we can give? Sir, I can give it to my permanent employee, and I can give it to my director as well of my subsidiary company. I can also give it to my holding company's director also. I can give it to my holding company ka employee also. Same thing, subsidiary ka employee, subsidiary ka holding company as well. However, remember, in the definition of employee, one person is not included. Who is the person not included? The promoters are not included. That's all, sir. Only the promoter is not included. No, people, one more person is also not included. Who? That is, a director is not included. Sir, here you are telling director is included. No, listen, I am telling you those directors are not included. Who? Along with relatives, or any body corporate, if they are holding people more than 10%, meaning up to 10 is okay. If the person is holding more than 10%, such director cannot participate in this particular ESOP. So permanent employee, whether in India or outside India, director, whole time or not, but cannot include an independent director. And employee does not include a promoter, and director does not include a director who, along with his relative or any other body corporate, holds more than 10% of shares in the company. Correct? And remember, in the case of a registered startup, this promoter and 10% the director condition will not apply for a period of 10 years in the case of registered startup. More important in ESOP than ESOP provisions only. Rest of it in ESOP is, people, we will grant an option today. You will have something called vesting period, meaning waiting period for a period of 1 year. After 1 year, you will have to exercise your options, meaning you have to say either an yes or a no. So you have always an option. If you want, you will say yes. You will say no if you don't want. So whenever you have an option to say an yes or no, that is when we will call it as what, people? ESOP, employee stock option. You have an option end of the day. That's why it's called as an option plan. Understood? Yes, sir. Okay, during that vesting period, always remember, if there is any dividends, you will not get. If there is any right to vote, you will not get in the vesting period. But whereas sweat equity, in the lock-in period, you will enjoy everything because you are already a shareholder in sweat equity. But you cannot transfer your shares. But in this case, people, you cannot transfer, you cannot vote, you will not get dividends, you will not get anything. But only in two scenarios: upon the death, if there is any permanent disability. In such cases, people, whoever is the legal representative or that permanent disability, the same person will get the shares on the same day of death. You need not have to even wait for the entire 1 year. Correct? Okay, that is one important thing. Remember, what is that? Next one is reduction of share capital, people. What is reduction of share capital? Section 66. Section 66. What does reduction of share capital say? Whenever, what is more important here? How can the reduction take place? When and all is a scenario. First one, people, extinguish or reduce a liability on any of its share in respect of the share capital not paid up. What do you mean by that? My total face value is 10 rupees. We have called 6 rupees. 4 rupees we have not yet called. We will tell them don't pay. That is one way of reduction of capital. Next one, cancel paid up share capital which is lost or is unpresented by available asset. Meaning what? It's a loss making company. My liability side is more, asset side is less. To balance it, I will call my shareholder and say, people, our total liability is 10 lakh. Because we have lost money, we have to reduce this to 6 lakh. If they are okay with it, people, we will be reducing our capital, and that is also one of the way called as capital reduction. What is that? Whatever is the money that is unpresented in the business losses, it's gone. So to even it, to equal it, I will reduce my liability side. That is second way. Third way, pay off any paid up share capital which is in excess. What is this, sir? Nothing but, people, whenever we have face value 10 and the entire 10 rupees is already paid. Now I will come and tell people, 6 rupees was sufficient for us. We unnecessarily took 4 rupees. We had taken, we will again repack. We will repay. In the first scenario, they never paid. We will say don't pay. Second scenario, they have paid, but we have lost it. So we will have to reduce it. Third scenario, they have paid. We have it, but it is extra, excess. We don't need it. We will tell you, we will give it back to you. Remember, for for capital reduction, there will be 4 approvals that is required. One is, people, you need to take board resolution. Next one, people, special resolution is mandatory. Next one, people, creditors approval will come into picture. Next one, people, NCLT approval will come into picture. If you are satisfying all of this, your capital will stand reduced. But remember, if you have missed giving any of the creditors details, then whatever is a reduction of capital, that will be considered as if it is ineffective. So your liability will be same like the previous liability. We will consider that nothing has changed. Clear? Okay. Next one, reduction of share capital. Next one, section 67. What is section 67? Restriction on purchase by company or giving loans by it for purchase of its shares. Meaning, there is a company. Let us imagine this company is company A. They're telling you company A cannot give money to any person to buy the shares of its own company. I cannot give money to any person, but this rule has certain exceptions. That exceptions is important. They can ask you, remember and go. What is that? First exception. It has been given lending of money by a banking company, meaning ICICI Bank has given money to some person. He has taken it as a loan. He has taken it and he has invested in its shares only. Now ICICI Bank cannot keep seeing for what and all the people are using the loan for, because it is its ordinary course of business. Meaning that is, it's your day-to-day business. In such cases, people, this scenario will not come into picture. So it is accepted, they exempted. You can give the loan to your any customer client as a loan. If he still ends up buying your own shares, it is still okay. The provision is made for purchase or subscription of fully paid up shares in the company or its holding company, or is held by trustee for the benefit of employees. Is nothing but, people, for the benefit of employees, we generally do it as something called as ESOP trust. So in the class, if you remember, we would have said a lot of things about it. I'm not going in detail now, but you can form an ESOP trust and all. You can give money to it. It is allowed. Next one, people, the giving of loans. They will ask you a question here. A hot question will be here only. The giving of loans by a company to its employees. I can give the money to employees. Why? People, remember, you're giving ESOP to your employees, but that fellow should have money to buy them, Noda. So the company only can give loan. Little recover from his salary. It is allowed. But how much I can give it to him? Maximum you can give it, people, is 6 months salary. Not beyond that 6 months. Maximum we allow is, people, 6 months. But what is the main thing? Remember, this you cannot give it to your directors. You cannot give it to your KMP. Anyone apart from them you can give it. If it is them, you cannot give it. They can ask you a question here. A company gave money to its CFO to buy the shares of its company. for 4 months salary. Is it valid or invalid? It is invalid. So in such case, remember the penalty and go. It can be clubbed. So wherever it makes sense, you try to remember. Is this clear? Next one, section 67. Section 67 shall not apply to a private company which has satisfied all the conditions. What is that? In whose share capital no other body corporate has invested in a company. Meaning what, sir? There is a XYZ Private Limited. No body corporate should have been a shareholder in XYZ Private Limited. Meaning a company or a LLP or a foreign LLP, no one should have invested money in XYZ Private Limited. Next one, if the borrowings of such a company from banks or financial institutions or any body corporate is less than twice of its paid up share capital, my paid up share capital is 10 crore. What is twice? Twice is people 20 crore or 50 crore. Now my question, whichever is lesser, which is lesser, 20 crore. In your private company, what is the total borrowings? If the total borrowing is 18 crore, then satisfied. If your total borrowing is 22 crore, then this condition is not satisfied. So your paid up share capital twice of it, 2. I'll get 20 crore or 50 crore, whichever is less, 20 crore. If your borrowing is going beyond that, then I cannot claim this exemption. The private company also this rule will apply. The third one, people, such a company which is not defaulted in repayment of such borrowings, meaning you have taken loans, you shouldn't have made any default in repayments, then the condition will not apply. Next, people, important one, the last one is buyback. In buyback, what and all is important? Sources is important. That is, you can do your buyback from free reserves, securities premium account and proceeds of fresh issue. But remember, if I am buying back equity, I cannot issue equity only. Yes. Next one, condition, resolution for buyback. If you are passing board resolution, the maximum I can buy back is 10% of paid up equity capital. If I am passing special resolution, people, I can buy back 25%. But remember, if I am buying equity shares, I can buy back 25% of paid up equity share capital. If at all I am buying back any other share, or if I am buying back the value, then maximum I can do is, people, 25% of paid up capital and free reserves of the company. Meaning, remember, I am passing special resolution. Now in special resolution, I will try to derive two things. One is, what is the total value I can buy back? What is the total number of equity shares I can buy back? After passing special resolution, the total value I can buy back is 25% of paid up capital plus free reserves. I will get one money number, that much number I can invest. Equity shares, maximum I can buy back is 25% of paid up equity share capital. Paid up equity share capital. So this I will get shares. This I will get value. So what you need to do? For example, you try to do value, you will get 20 lakh. The number of shares you might get, say for example, 2 lakh. Then the maximum I can pay is rupees 10 per share. That's the buyback you can do. That's how you will get the numbers. Understood? Sir, post buyback debt to equity ratio shall not be more than 2:1 after buyback. Next one, procedure and all, explanatory statement, declaration of solvency. The directors have to give a declaration that the company will not become insolvent in the next 1 year. We have made complete, we have gone into the affairs of the company. There is absolutely no problem. We have done our research. Next one, sir, the time limit for completion of buyback, you have to complete within 12 months. And you cannot make a further issue of the same capital for the next 6 months. And remember, you cannot make a further buyback. There is always a cool off period. No, there is a cool off period of not more than 1 year. Remember. So you cannot do a further buyback in the next 1 year, and you cannot make a further issue of the same share. Meaning, if I have purchased buyback, I have done a bought back of shares of my equity today, I cannot issue the same shares again within the next 6 months. And between two buybacks, there should be at least a cool off period of 1 year. Correct. That is section 71. Okay. Buyback. Okay. Debentures. What is the main thing? Remember DRR and DRF. DRR is how much? The maximum you need to create is 10% of total outstanding debentures. You will create 10%. That is DRR. What is DRF? You will create 15% out of the debentures that is going to mature during the year. You will separately invest it in an account by 30th April every year. You will calculate this 15% on the total debentures that is going to mature during the year. Those 2 points are very important. In addition to that, which point is important in case of debenture? DRR. Of course, this table is also important for whom this is required. Who shall not be appointed as a debenture trustee? No one go. They can give you a scenario. Who? A person who beneficially holds shares, meaning a shareholder, cannot be a debenture trustee. A person who is a promoter, director or KMP or any other officer or even an employee of the company of its holding subsidiary or an associate company, you cannot become a debenture trustee. So no one can become. Next one is a beneficially entitled to money which are to be paid to the company otherwise than as remuneration, meaning you are a debenture trustee in our company. We are giving you remuneration, that is okay. Apart from remuneration, if you are getting anything, you are disqualified. A person who is indebted to the company, someone who has taken the loan from its company, associate, subsidiary, holding company, we cannot appoint such person because they will be biased. They will not act properly. A person who has given guarantee to someone, meaning loan has been taken from A, from ICICI Bank. The guarantee has been given by me. If A doesn't pay, I will pay. Then even I cannot be appointed as a debenture trustee. Next one, has any pecuniary relationship with the company amounting to 2% or more of its gross turnover or total income or 50 lakh rupees, whichever is less. Pecuniary means people monetary. If at all a person has people monetary relationship which amounts to 2% or more of its gross total income or 50 lakh rupees, whichever is less. So you take the company's what is a total income, 2% or 50 lakh, whichever is less. In such person who is having that relationship with the company, imagine a raw material supplier. That person cannot be appointed as a debenture trustee. Is relative of any promoter or any person who is in the employment of the company as a director or KMP. Relative of promoter, relative of director, relative of KMP cannot be appointed as a debenture trustee. Sir, what if there is any casual vacancy? The board of directors only can fill the casual vacancy. But remember, if casual vacancy is due to resignation, then the majority of debenture holders also have to agree such casual vacancy. Meaning, a person A was a debenture trustee. He left. Why? Resignation. We want to appoint a person B. They're telling you this approval should also be done by the majority of the debenture holders as well. If it is due to resignation, any other purpose, then the debenture holders approval is not required. Next one, people, can we remove the debenture trustee? Yeah, possible, provided it should be approved by the holders of not less than 3/4 in value of the debenture outstanding. That is what, sir, if my total debentures is 1 lakh, 75%, 75,000 worth people should come and do it. Debenture trustee shall take steps to protect the interest of debenture holders and redress their grievances, correct? And sir, when will the debenture trustee conduct a meeting? Whenever any event happens, people, which constitutes a breach or default, meaning imagine we did not repay the interest on time, we did not repay the principal on time, so some breach has happened, I will call all of them for a debentures meeting. Next one, whenever 1/10 of the debentures in value, if they are requesting a debenture trustee to conduct a meeting, we will conduct a meeting. Remember, they can ask you this question also. Next one, sir, this one also they can ask. Imagine in a debenture trust deed, if there is any clause which will exempt the debenture trustee from any of its obligations, negligence if they have done, liabilities, if that clause is exempting the debenture trustee, meaning if you have only done a negligence, because of you the debenture holder suffered any loss, but in the debenture trust deed you have put a clause, what? At any given point of time, because of my negligence, anything happens also, the company cannot hold me accountable. If I've put that clause, people, that clause will be considered as ineffective. It is void. But if the if the debenture holders want, they can waive this. It's okay. You don't have to give us any penalty. You don't have to pay us any compensation. If the debenture holders wants, they can waive off. How many? 3/4 in value. If they want, they can waive off. It is allowed. They can ask you a question here also. Important. Remember and go. Okay, done. Okay, next one, people, deposits. So in deposit, I hope you guys are able to understand. Yeah, I'm trying to rush through those topics as quickly as possible. If you guys have read it, meaning you guys have studied, and if you guys are sitting, means this point should just like that keep popping up. So it's like, you know, you're reading almost like, I don't know, if I take the entire syllabus, so easily it would have been around 120 topics. 100 topics to 120 topics easily. So you're reading 120 topics with me now. Probably, I don't know, within another 1.5 hours, 2 hours, I want to finish it. So, you know, if you guys have planned your day better and if you guys have properly prepared and all, and I think it's a very good consolidated revision that we are doing. And I hope you're understanding. I'm taking that points main. And that's what is a differentiator in a marathon. And this is what I'm saying. I'm telling you that point and we are discussing that. You're getting the point. Hello. Hey, macha. Not just commenting. Simply, hi sir, Allah. You have to, oh, yes. Okay, depositor definition, of course, now much I am not touching it is a landmine. Directly we'll go to rules. So in deposits, what all is important, people? First important thing in deposits, what is that? The deposit rules will not apply to some companies. Which are those companies? The deposit rules will not apply to banking company, non-banking financial company, HFC companies, such other company as specified by central government. This they will give you in the question, that is ICICI NBFC. That means this deposits provision itself is not applicable. If they want, they can take from members. If they want, they can take from public. We don't have a problem. Yes, the section 73 itself. Why? Because what is section 73? According to provision section 73, the prohibition contained in section with respect to acceptance of relief or deposit from public shall not apply to the following types of companies. You do whatever you want because that is your principal business. Correct? Okay. And what else is another point? Remember, in the case of a public company, if at all if you're raising, not public company, if you're an eligible company, if you're raising deposits from public, then remember it has to be secured. Charge is mandatory. Correct? The charge also, wherever you have seen, the charge should always cover the principal as well as the interest component. Both are to be covered. Remember that. Yes. Okay, next one, maximum amount of deposits. Okay, eligible company. Sir, we know that deposits, in section 73, we can raise deposits from members. In section 76, we can raise deposits from public. So, who can raise deposits from public? People will get confused here. People will just write public company can raise deposits from public. Allah, eligible companies can raise deposits from public. So who is an eligible company? It is a public company only, but having certain limits. What is that? A public company having a net worth of not less than 100 crore rupees. Minimum is 100 crore, or a turnover of not less than 500 crore rupees. So 100 crore net worth, turnover is 500. Remember this net worth. Very rarely you will see net worth. Generally it will be paid up capital. So by default you guys will write off also paid up capital only. So remember, eligible company is a company which has a net worth of 100 crore and turnover of 500 crore. Is this clear, all of you? Okay. Next one, sir. What is if it's a eligible company, this one credit rating should be taken for the entire tenure of the deposits. Remember, that is important. Sir, common rule. What is the tenure of deposits? The minimum will be 6 months. Maximum will be 36 months. Sir, can I take anything less than 6 months? Possible. What is that? You can take it less than 6 months, but it cannot be less than 3 months. Provided whatever you have taken for less than 6 months, but up to 3 months, it will be only for your short term requirement, and it cannot be more than 10% of your paid up share capital plus free reserves plus securities premium account. Whatever you have accepted for less than 6 months, but up to 3 months, that cannot be more than 10% of paid up share capital, free reserves plus securities premium account. Okay, what is the maximum tenure? Okay, we saw. What is the quantum of deposits? Eligible companies can take 10% from members, 25% from public. 10 or 25 eligible. If you are a non-eligible company, meaning it can be a private company also, a public company not satisfying the limit of 100 and 500 also, they can maximum take 35% from members, meaning your shareholders. Government company, you can take 35% from public. All the limits here are on paid up share capital plus free reserves plus securities premium account. Next one, ceiling on rate of interest and brokerage payable. Whatever is prescribed by RBI people, that will be my maximum ceiling. I cannot go beyond that. Whatever is the brokerage prescribed by RBI, I cannot go beyond that. Where is it prescribed? We have told NBFCs you cannot pay more than this. Whatever we have prescribed there, the same thing will apply to you also. And remember, whoever is applying or whoever is investing money in these deposits, that money should be their own money. They should have not borrowed it from anyone else. It should be their own money, and that has to be given as a declaration. Deposit in joint names possible, provided it should not be more than 3. Documents and filing. Remember, whenever we receive the money, we have to, within 21 days, we have to give them deposit receipts. Within 21 days, we have to give deposit receipts. And after we give deposit receipts, within 7 days, we have to enter their names in Register of Deposits. Register of Deposits shall be maintained for a period of 8 years. 8 years from when? 8 years from the date of latest entry made. You maintain it for. Correct? Okay, done. Next one, no right to alter penal rate of interest. Register of deposits, entries, premature payment of deposits. Can I make premature payment? Yes, sir. Within 6 months, not possible. After 6 months, possible. So imagine if the total tenure was 3 years. Sir, after 1 year, I want to come and take back my money. Is it possible? Yes, sir. If my total interest is 10%, I will deduct it by 1%. Whatever period the deposit has run, that period will be whatever is the rate of interest, we will reduce it by 1%. And remember, when you're calculating anything which is 6 months or more, you have to round it off to 1 year. Anything less than 6 months, you need to ignore. Meaning, if my deposits have run for 1 year, 4 months, this 4 months will be ignored. It will be considered as 1 year only. If my deposits have run for 1 year, 7 months, it will be considered as 2 years, and you will be entitled for 2 years interest. Yes, for the period for which the deposit has actually run. Now, what do you mean by that? Sir, 1.7 will be considered as 2. You will be entitled for 10% rate of interest per year minus 1%, 9%. You are entitled for 2 years. Whatever the deposit has actually run, the deposit has run for 2 years. So for 2 years dividend, the interest you will get. Reduction of rate of interest is not applicable if you have done it to comply with rule 3. What is rule 3? The maximum tenure of, the maximum quantum of deposits, 35%, 10 and 25%, government company 35%. Sir, now my deposits have gone beyond that. Why? Company has done a buyback. So my paid up share capital has reduced. My free reserves have reduced. So automatically the limits I would have gone beyond it, no. So to satisfy that, I'm paying some people, I'm calling them and I'm paying out. So to satisfy if you're paying these people, they're telling you it's okay, this particular provision will not apply. And if at all you're repaying it to the Navy, Air Force, Army during the emergencies, it is not applicable. Can you get a higher rate of interest? Yes, provided you need to renew the deposits for a period more than the unexpired period. Meaning, sir, 3 years is my deposit, sir. 2 years is completed. 1 more year is pending. Now, if I renew my deposits for more than 1 year, meaning imagine I will renew my deposit for another 2 years. So total 3 years. No, they are telling you I will be eligible for a higher rate of interest. If at all I'm, what is that? If I'm renewing my deposit for more than the unexpired period. Okay, 74. Okay, rest and all is okay. That was quite okay. Charge. Hey, macha, is it becoming a marathon only, da? Am I going through everything, da? Okay, charge. Types of charge. There are two types of charge. One is called as fixed charge. One is called as floating charge. Fixed charge people created on a fixed asset of the company which does not fluctuate. And if you want to sell it and all, you have to take the lender's approval. Floating charge which fluctuates over a time. You guys can sell it and buy it in your ordinary course of business. You do not have to take the lender's approval to do anything with this particular property of that particular asset. Examples of floating charge will be debtors, stock in trade, stock, etc. The example for fixed charge will be people, land, plant and machinery, etc. That is types of charge. Done, na? Next, in charge, what else is important? So until crystallize the floating charge, when will the floating charge gets crystallized? When the company goes into liquidation, when the company ceases to carry on its business, meaning production is stopped. When the creditors or debenture holders take steps to enforce their security. If you guys remember people, you will be filing one form. The form is called CHG6. What is this? Appointment of a receiver or a manager. You'll file it with ROC. No, that is called taking steps. You're appointing a manager to acquire that property on happening of any event specified in the deed. Non-failure, failure to pay interest, failure to pay principal. That is one of the reasons. Yes, sir. A duty to register charge. You will be registering a charge in form CHG1. If it is any other thing, if it is debenture, you will have to file form CHG9. It has to be filed within 30 days of creation of charge. If within 30 days, if I am not able to do people, they will give me one-time extension of 30 days. Even within 30 days, I am not doing it, people, I'll get one-time extension of 60 days. The total I will get is people 120 days. Here, don't get confused. In your book, they would have written 60 days. The 60 days is from the day of creation of charge. I'm just telling you extra. I have 30 days only. 60 days will count from here. They are telling you. I'm telling from here it is 30 days. 30 plus 30. Yes, sir. What is the other important one? Other important one is verification. Who will verify? Depends upon where the property is. If the property is situated outside India, then people, it shall be verified by the, what is that? It shall be verified by the company, common seal of the company, or meaning someone has to verify, authenticate, sign it, right? Who will verify? They're telling you common seal, or under the hand of any director or CS of the company or an authorized officer of the charge holder. So who will authenticate it? It will be a director, CS or an authorized officer of the charge holder. Who is the charge holder? Always the charge holder is the lender. I'm talking from a bank's point of view. Under the hand of some person other than the company who is interested in the mortgage or charge. Meaning what, people? Imagine if we have taken mortgage. Imagine people if we have given our property on lease. So they're telling you under the hand of person other than the company who is interested in the mortgage or a charge. So imagine people, there can be a person lease. There can be debenture trustee. He can come and authenticate on behalf of debenture holders if the property is situated outside India. If the property is situated in India, people, the answer will be same. Only thing is, this third point will be extra. If it is in India, these two will apply. Anything outside India, the third point will come into the picture. Correct? Okay. What else? Void against. So if at all consequences of non-registration, people, if you do not register a charge, what will happen? So imagine if I've given, I've taken loan from ICICI Bank. if I do not register this charge on time, what will happen, people? ICICI Bank will be treated as void against the liquidator, void against the creditor. What do you mean by that? On the day of repayment, the ICICI Bank is coming and standing in the queue. He's trying to come front because he's thinking he's a VIP, secured creditor. No, we will ask, is your document registered? If his document is unregistered, we will tell him, hey, go, go and stand in the queue. That's the meaning of void against the liquidator. I'm not telling we will not repay you your money. We will repay, but we will not give you priority. Same thing, void against creditor. Whenever there are two parties, one party has not created, one party has not registered the charge, one party has registered the charge on the same property. Whoever registered the charge on the property first will enjoy the priority. Okay, but remember, it will never discharge the debt. I'm not saying that just because it is not registered, your debt only will come to an end. Your loan will continue. The liability will always be there. Application for registration of charge by a charge holder. If at all the lender, if the borrower does not register the charge, then within next 30 days, the lender can register the charge and the lender can recover all the expenses that has incurred by him from the borrower. You can do it. So ICICI Bank has given the loan, I can recover everything. But remember, before the ROC registers the charge, they check with the borrower and they say that one person is trying to create a charge. Is it true? Have you taken any loan on this property? The company will have 14 days. The borrower will have 14 days to reply. Within 14 days, if you do not reply, it will be considered as deemed approval. Acquisition of property subject to charge and modification of a charge. Remember, they may ask you this. If at all I am acquiring any acquisition by a company of any property that is already subject to a charge, meaning Kingfisher has taken loan from ICICI Bank on all its properties. Now that particular property is being purchased by Infosys. They're telling you it is Infosys' responsibility to ICICI Bank to tell, going forward, I will be the charge creator. Going forward, I will have to pay. Please update in your records. It is no longer Kingfisher, it is me. Or imagine some modification, meaning Kingfisher only has taken a loan at the rate of 10% interest. Now it is getting 14% rate of interest. Tenure is changed from 4 years to 8 years. So there is change. No. In such case, we will file something called modification of a charge. Infosys will file. If at all Infosys is buying such property, or Kingfisher will file. Whenever there is change in the rate of interest or any terms agreed in the charge, in which form we will file? We will file in the form CHG1 only. Modification will be always in the form CHG1 only. ROC will give us, for first time we file registration of a charge, ROC will give us CHG2. When we file modification, ROC will give us CHG3. Meaning certificate of registration of modification, CHG3. Understood? Pakkana? Hello? Sure. Next one. Section 80, nothing but constructive notice. If a charge is filed with ROC, then it is considered that everyone is aware of it. Tomorrow you cannot say that, sir, I was not aware that the company has already taken loan on this property. No one informed me. You cannot say that. That is section 80, nothing but constructive notice. Once it is sitting in the public domain, then it is assumed that everyone is aware of it. Company to report satisfaction. Kingfisher repaid the loan to ICICI Bank. Of course, you need to intimate this to ROC. Sir, whatever is the money we have repaid, you will intimate it in the form CHG4. ROC will reply to you, okay da macha, I have taken it on record in the form CHG5. Now, whenever a person does not repay the loan on time, then we appoint a manager or a receiver to go and take control over the property that is creating a charge. We intimate that in the form CHG6, appointment of a receiver or a manager. We need to intimate this to ROC. When will we intimate? Within 30 days. 30 days of what? Whenever we appoint him or whenever his job is done. So even after cessation, sir, his job is completed. Within 30 days of cessation, within 30 days of appointment, both we will intimate in form CHG6. What is CHG7? CHG7 is nothing but register of charges, which shall be maintained permanently. But remember, the loan documents shall be preserved for a period of 8 years from the date of repayment. Loan document, the loan, that is basically a document creating a charge. So whatever is your loan document, you will maintain it for a period of 8 years. This register of charge, you will maintain it for a period of permanently. Okay. And remember, sir, duty of satisfaction of a charge, I have to file CHG 4 people within maximum people. The time given to me is 30 days. Sir, what if within 30 days I was not able to do? The maximum extension given is 300 days. Sir, what if even within that time I was not able to do? People, you can go for condonation of delay. That is, you ask central government's approval. If central government deems fit people, they can give you an approval, and you can even file satisfaction of a charge beyond the 300 days as well. But remember, this option is not available for registration of a charge. It is only available for satisfaction of a charge. Remember this. Correct. Appointment of manager and all, rectification of CG. Section 87. Section 87 is nothing but that condonation of delay, CHG 8 beyond 300 days. And also the same section will apply. If at all, imagine in any of the particulars you have filed with the ROC, that is, you are creating a charge, there is some mistake in that particulars. In such case, they are telling you people, CHG 8 if you file, that is, you can say where any statement has gone wrong, any mistake has happened. That mistakes can be, what do you say, materialized, or you can change it. CHG 8. CHG 9 is debentures. Done. Management and administration. Okay, I'll try to tell here only. We'll see. Registers, people, every company should mandatorily maintain registers. Section 88. We maintain it for equity shareholders in the form MGT1, and any other security holders, debenture holders, we maintain it for MGT2. MGT1 we preserve permanently, MGT2 we preserve it for a period of 8 years. And can we maintain foreign registers? Yes, possible. It will be maintained as per the principal copy of the registers only. Whatever is the principal format, same format we maintain. Opening of a foreign register is optional. It is not mandatory on the company. Remember that. And whenever a foreign register is opened or closed, you need to intimate ROC, inform MGT3 that, sir, we have opened or we have closed this form within 30 days of opening or within 30 days of closing. Any entry made in the foreign register should be transferred to the principal register also within 7 days. This foreign register can be closed whenever required. Correct? That is your registers. Okay, done. And remember, sir, register index of registers is not required when the number is less than 50. 50 index of members is required. Section 91 is nothing but closure of registers. A company can close its registers to determine the cutoff date, meaning dividends, rights, bonus and all we need to know. No, we can close our registers to know that day who is a shareholder. Remember, a company can close its books at once. It can close 30 days. Once I keep it closed for 30 days, it will be closed. Remember, during the closure, the books will not be available for inspection. Sir, in aggregate in a year, people, I will close it for 45 days. Plus, sorry, once is 30 days. In a year, everything put together, how many ever times you close in a year, everything put together is 45 days. Is this clear? Remember, whenever you want to close, 7 days prior intimation has to be given to the shareholders. If it's a listed company, we give it in newspaper. If it's a private company, newspaper advertisement is not required. Private communication is good enough. Okay, done. That is the section. SBO. What is SBO, people? Whenever I've made complete section of SBO. If possible, try to see that only if you guys have time. Whenever a person is having the 10% or more of shareholding or more of voting rights or out of total dividend, one person is getting 10% or more, or any person who has a control, such person's details, indirect shareholding, we have to report. If a person is having a control, imagine 51% in company A, and if company A has invested say 10% of shares in company B, the company B should report to ROC that in my company, company A is a significant holder in whose company the control is with this person. This person is Mr. A. We need to disclose this person's details. This person is called as the ultimate significant beneficial owner. Then next one, people, annual return. Annual return is given in section 92. Annual return, people, will be in the form MGT 7. And if it is a small company and OPC, you will maintain it in the form MGT 7A. And you have to file annual return within 60 days of your AGM. And what else? It shall be signed by a director and a CS if a company has a CS. If company has no CS, then you have to sign it with PCS. For OPC, this condition is not required. That is, one director is sufficient. Section 94, people, is nothing but your inspection, your registers and all. Basically, whatever we saw, who can inspect section 94. Place of keeping and inspection of registers. In this, the important point is, where can I keep my registers? The registered office of the company can be the place of registers. The registers can be kept at the registered office of the company, or it may also be kept at any other place in India. So first preference is given to registered office. If it is not registered office, then you can go to any other place. Where is it any other place? You can keep it in that place where more than 10% of the total number of members as per your registers reside. Meaning, sir, let us imagine more than 10% of my shareholders reside in, say, for example, Telangana. I can go and keep it in Telangana. And remember, people, provided I need special resolution. Remember, if you want to keep it in the same city, town, village, also you need special resolution. If I want to take it beyond the city, town, village, I can keep it only in those places where more than 10% of the shareholders reside. That is main thing. Open for inspection and all. This is okay. Notice of a general meeting. Notice of a general meeting should be given how many days in prior? It should be given at least 21 days, 21 clear days in advance. Agreed? So do not count the day of the meeting. Do not count the day of giving the notice. Excluding that 21 days gap should be there. And always remember, whenever you are sending by post, add 48 hours to it. And remember, people, in the case of any other general meeting, can we give it a shorter notice? Shorter notice is possible. Sir, should I always follow 21 days? No, people, less than 21 days is also fine. We do not have an issue. Only thing is, people, in case if it's an AGM, at least 95% of the members entitled to vote have to agree. Entitled to vote, generally we say it as equity shares. If they agree, people, I can conduct my AGM at a shorter notice. In case of any other general meeting, let us imagine EGM, holding company having a share capital, then people, majority number of members entitled to vote and who represent not less than 95% of such part of the paid up share capital, majority in number. That means what, people? Imagine if my company has 100 shareholders, at least 51 shareholders holding 95% of share capital. There is a twin condition here. Remember, both the condition to be satisfied. A company, if the company has no share capital, company limited by guarantee, not less than 95% of the total voting power exercisable at the meeting. In this is the questionable point. Remember and go. Okay, next one. Quorum. What will be the quorum? If at all, if it's a private company, 2 members personally present. If it's any other company, people, if your article prescribes a higher number, then you need to follow your articles. If not, if it is 0 to 1000, then it will be 5 members personally present. If it is 1001 to 5000, then people, it will be 15 members personally present. It will be 5001 and above, it will be 30 members personally present. Agreed? That is your quorum. And remember, if it is authorized representative of President of India, Governor, body corporates, people, section 112 and 13, will be counted for the purpose of quorum. Proxy will be never counted for the purpose of quorum. Penalty, what is this penalty? Only one place I've said, remember the penalty, generally I don't say also, is whenever if you are not complying with section 96, 97, 98, try to remember this one thing. So if there is a non-compliance in conducting AGM, AGM as per tribunal's notice, EGM as per tribunal's notice. In such case, people, they are telling you that you cannot have what? You cannot have a, basically there will be punishment. That is as per section 99. Company and every officer shall be punishable with fine which may extend to 1 lakh, and in the case of continuing default with a further fine which may extend to 5,000 rupees for every day during which the default continues. Understood? Just give me a second. People, I hope you saw that. Okay, next one, restriction on voting rights. Again, a peculiar point. People, I'm not saying this EGM, AGM and all is not important. We would have discussed so many times. So I thought, that is already covered in marathons and all. I've tried to point out those peculiar places that you can expect a question, and that is what I've tried to point. So that is the intention of doing it. You guys don't skip and go. Yes, sir. Okay, so restriction on voting rights. Can a company restrict any person from, voting in a particular meeting? Is it possible? It's possible, it seems. But what is the ground? A possible question can come here. A no member shall exercise any voting right in respect of any share registered in his name on which any amount is due from him on calls. Meaning, if call money is not paid, people, you cannot exercise voting rights. Or, this is important, if he has not paid any other sum to the company, or in regard to which the company has exercised the right of lien, meaning until you pay, we will not give some asset which belongs to you if it is with us. So if a company has exercised such right, the company can restrict the voting rights on such person, provided always, remember people, if a company to enjoy this restriction of voting rights, if they want to do it, then one thing is mandatory, people. It should have been mentioned in the articles of association. If it is not mentioned, you cannot do. So when can we restrict the voting rights? One is, people, you can restrict it when it is given in articles. Next one, when the calls is not paid or any other sum not paid, or the company should have exercised, the company should have exercised right to lien. In such case, people, I can restrict my voting rights. Clear? Done. That is one thing which I thought it is important from exam point of view. Next one, people, who can demand a poll? Important. And when can a poll be demanded? A poll can be demanded either before the results by show of hands or even after the results of show of hands. Can you withdraw the poll? Yes. Who can withdraw? It can be withdrawn even after the request is made. It can be withdrawn by the people who has made the request only. Even after the decision also, the poll can be withdrawn. And can a proxy demand for a poll? Answer is yes. All these questions can come. Next one, who can demand? If a company is having a share capital, then a member present in person or proxy having not less than 1/10 of the total voting power. So minimum 1/10 of the total voting power, or holding shares on which aggregate of sum not less than rupees 5 lakh has been paid up. People, do not get confused here. It is not whichever is less, whichever is higher. 1/10 of total voting power or a person holding 5% of shares. Either of them can demand for a poll. That is the meaning of it. Clear? Okay. In case of any other company, members not less than 1/10 of the total voting power, these people can demand for a poll. That is important. Withdraw and all, I told you. Poll. When should we conduct a poll, people? The poll shall be conducted forthwith, meaning immediately. If it is to decide these two things, what is it? If it is for deciding the adjournment of a meeting, if it is for deciding the appointment of a chairman, poll has to be conducted forthwith. In any other case, it can be conducted within 48 hours of the demand. So in respect to all the other types of votings, e-voting, postal ballot and all, poll has more points. So that's why I just took it and I tried to say that it is important. Who can demand poll? Okay. Next one, 108 applicability. 108 is nothing but, people, e-voting. So e-voting is also in one way a peculiar point only. So applicability, equity listed companies on recognized stock exchanges. Equity listed, all companies having 1000 or more members on them, poll is, e-voting is applicable. However, this does not apply to Nidhi companies and institutional investors. For them, this particular condition is not applicable. Correct? And always remember e-voting. If I cast my votes electronically, I can still go and attend the meeting physically. It is allowed. Agreed? And e-voting should be open at least for a period of 3 days. It should mandatorily end at 5 p.m. preceding the date of the meeting. It should be open for a minimum period of 3 days. It should mandatorily end preceding date. So if today is the AGM, it should end the preceding date, meaning previous day at 5 o'clock. So person who has attended can still come and, who has voted can still come and attend the meeting but cannot vote. In e-voting, there will be no proxy and all, remember. Scrutinizer and all, okay, I'm not going there. Section 111, what is section 111? Circulation of members' resolution. There the important point is they will ask you the timelines. That is, if a shareholder wants to add his resolution also to the company's discussion, can he do it? Yes, possible. If at all whatever you want to discuss, it is in a form of resolution, then you need to give your notice at least 6 weeks before the meeting. Let us imagine if a company is conducting its meeting on 30th September 2026. 6 weeks prior, people, somewhere I'm telling you 15th Venda, at least by 14th August 26. I'm just taking a rough calculation, but you take it weekly. I have to take 6 weeks prior. I have to give my notice of the resolution. Sir, can you please add mine also? I need to request to the company at least 6 weeks prior. Sir, I need to discuss something where it is not about a resolution which requires a prior notice. In such case, sir, I need not give it 6 weeks prior. Even 2 weeks prior is also sufficient. Sir, what if I gave on 14th August, but the company called off a meeting on 15th of September? So technically speaking, between these 2 days, there is no 6 weeks gap. So after you giving your request, if a company calls for an AGM before the date you thought, the 6 weeks condition will be considered as it is deemed to be satisfied. So after you giving the request, the company calls for an AGM, your request is deemed to be satisfied. So you need not have to worry about it. So whatever is a request, the company will further give it to all the other people. Next one, ordinary special people. What is special resolution? The number of votes cast for the resolution would be at least 3 times of the votes cast against the resolution. Meaning, if number of people who said no is 5, for a special resolution, you should get 3 times of the votes, meaning 15. If you get 15 votes, people, it's called as a special resolution. Remember, people, number of people who did not vote, number of people who did not attend the meeting, or number of people who attended the meeting, all these are irrelevant to decide our special resolution. Clear? And next, what else is there? 118 people, minutes of a meeting. Every company shall maintain minutes of a meeting in a separate document. Every meeting minutes has to be separate. The minutes cannot be tampered. It should be maintained permanently. Whenever a company is following minutes, section 118 subsection 10 says that every company, while following minutes, they have to mandatorily follow secretarial standards while they are complying with the minutes of the meeting. Remember that. So that is in this. Chapter 8, dividends, people, main 3 things I have put. What is that? Rule 3, what is rule 3, sir? Whenever a company does not have adequate profits, can a company still declare dividends? Is it possible? Yes, it seems. How? You need to satisfy these 3 conditions. Condition number 1, the rate of dividend declared shall not exceed the average of the last 3 years dividend. People, here, very important thing where students will not understand. Sir, my year 1, I did not declare anything, it was 0. My year 2, it was 10%. My year 3, it was 11%. So should I do it divided by 2 or divided by 3? You will do divided by 3 only. So it will be 7%. Sir, what if I don't have any record at all? Meaning my past years it's not there only. If nothing is there, this condition itself will not apply. That is condition number 1. If you are paying dividend out of your free reserves or when your current year profits are not sufficient, in that case you will do this. Next one, condition 2. The total amount you can draw from your free reserves can be maximum 10% of paid up share capital plus free reserves. If my free reserves is 1 crore, from this how much money I can take? I can take my paid up share capital plus free reserves. You see how much it comes. Into this do 10%. Imagine it is coming to 20 lakh. I can withdraw maximum 20 lakh. That is condition 2. But remember, whatever money I have withdrawn, 20 lakh I have withdrawn, in that the current year losses has to be first set off. Meaning in my current year, if 10 lakh loss is there, so I need to do 20 lakh minus 10 lakh. So the maximum I can pay dividend is 10 lakh rupees as per condition 2. What is condition 3? Sir, I have out of 1 crore, I am giving 20 lakh as dividend. What is the minimum money I have to keep in the free reserves? You cannot use everything. Free reserves for future you should have something. So the minimum you need to keep behind in the free reserves, people, should be after withdrawing. The balance in the free reserve should not go less than 15% of paid up share capital. So imagine if my paid up share capital is 2 crore. What is 15% of 2 crore? 2 crore, what is the 15%? 30 lakh. So 30 lakh. So we are withdrawing how much? 20 lakh. Correct now? We are withdrawing 20 lakh. Meaning what? According to condition 3, I have to at least keep 30 lakh. Oh, definitely possible. Not at all a problem. Understood? Hello? Hello? Clear? And people, one more thing. Remember here, whenever I am doing this 30 lakh, in condition 2, though I got 20 lakh, but how much did I utilize to pay? 10 lakh only, no? So I need to take here 10 lakh only. So out of my 1 crore, maximum I can withdraw as per condition 2 is 10 lakh. So how much is left behind here? 90 lakh, which is satisfying my third condition. That is how you need to satisfy. That is how you need to follow it. Sir, and dividend can be paid from what and all, sir? Dividends can be paid out of what? Sources, sir. Surplus in the P&L account, profits of the financial year in which such dividend is to be declared, profits generated in the financial year till the, no, this is the interim dividend. Where is that main thing? Source of declaring dividend, profits of the current financial year, profits of any previous financial year, meaning free reserves or P&L surplus. I can declare it out of current financial year, I can give it out of surplus in P&L, I can declare it out of free reserves also. If it is my normal dividend, if it is my interim dividend, people, I can declare it out of surplus in P&L account, profits of the financial year in which such dividend is sought to be declared, meaning people, 1st April 25 to 31st March 26. So in this year, I have good profits. So I will declare of dividend in 15th of April 2026. I will not wait for AGM only. Can I declare like that? Yes, possible. So next one, my quarter 1 is done. Quarter 2 is done. These two are profitable. In quarter 3, can I pay? Yes, possible. Next one, declaration of interim dividend shall be ratified. The company is incurred. Okay, where is that? Okay, next one, interim dividend we'll see. Important. How much interim dividend I can maximum give? Sir, if the company has incurred loss during the current financial year up to the end of quarter immediately preceding the date of declaration of interim dividend, such interim dividend shall not be declared at a higher rate than average rate of dividend declared by the company during the preceding 3 financial years. First thing, people, rule 3 will not apply to interim dividends. The second thing they are telling you, imagine sir my Q1 is a loss, imagine sir my Q2 is a loss, I want to declare dividends in Q3. The only condition that applies is average of the last 3 years, whatever is average. I cannot give more than that. I know you guys can have a question. Sir, when my Q1 is a loss, Q2 is a loss, I cannot declare dividend. No sir, people, we have something called surplus in P&L account. Using that we can declare. People, remember, surplus in P&L account and free reserves are not completely the same. Surplus in P&L account is nothing but in the P&L account from the previous year, whatever is the unappropriated amount, the money which is not yet carried to free reserve, the money is still lying in your P&L, that we call it as the surplus in P&L. That you can use it and you can declare it is allowed. That is one thing I wanted to tell you. Next one, sir, utilization of IEPF. Off late they are asking you, people, is there any mandatory amount that we need to transfer it to free reserves and all? Absolutely no. If you want, you can declare the total money you earned during the year completely as dividend. It is possible. Sir, IEPF will be utilized for what? Remember, utilization, they will ask you a question. To refund 7 years if no one has claimed. I hope you remember the timeline. A dividend after declared, within 5 days it has to be transferred to a separate account. Within 30 days the payment has to be made. Within 7 days you have to transfer it to an unpaid dividend account. It will sit here for 7 years. In 7 years no one will come and claim. You will transfer the dividend along with that even shares plus interest to IEPF account. Now what and all we can use that money in IEPF for? First one, refund. Someone came and asked, give it back. Next one, promotion of investor education protection fund. That means seminars, webinars, giving you messages, video calls and all they will do now. Distribution of any disgorged amount. What is that, sir? Sir, we have taken money from someone who has done some illegal gain. Harshad Mehta, he has earned a car, he has earned a bike, he has earned bangla. We will take away all that money. And that money we will give it to those people who have suffered or who are suffering loss. Reimbursement of legal expenses incurred pursuant to class action suit. We saw now in Prospectus chapter. That is what I am telling you. Any other purpose, we can use it only for these purposes. They will clearly ask you a question. IEPF, the government wants to use the fund for this purpose. Is it valid? Is it allowed? Remember, the chances of question coming from here is more. Clear? Okay, the next one, people, is punishment for failure to distribute dividends within 30 days. People, again, penalty can be important. Generally, if you fail to distribute dividend, people, then there will be a penalty. And the penalty will be visible. Company fails to pay declared dividends or fails to post dividend warrants within 30 days, then such case, people, every director of the company shall be punishable with imprisonment of up to 2 years if he is knowingly a party to the default, meaning willfully if you are doing, and he shall also be liable to minimum fine of 1000 rupees for every day during such default continues. That is for government. What is the benefit for you? 18% you will get as an interest. Sir, however, this liability will not come into picture in these scenarios. When, sir, where the dividend could not be paid by reason of operation of any law, meaning death, such things have happened, or a person is staying in Pakistan, we became alien enemies. Where a shareholder has given directions to the company regarding the payment of dividend, I have clearly asked, I am a shareholder, I asked Infosys, sir, can you please send me dividend to my HDFC account? But that HDFC account is closed. Temporarily it is inoperative. So they tried depositing the money. They were not able to deposit. So they have to clearly call me and say, sir, as per your direction, we were not able to proceed. If they do not communicate this, people, it is considered as non-compliance. Next one, people, where there is a dispute regarding the right to receive the dividend. Meaning, people, sir, there are two people fighting that these shares belong to me, these shares belong to me. So there is a dispute going on. Where the dividend has been lawfully adjusted by the company against any sum due. You have not paid call money. We have adjusted. It's okay. Where for any other reason, but not at the default of the company, then people liability will not come to the company's point of view. If not, there will always be a liability. Next one, sir. Accounts. Okay. People, where do we keep the books of accounts? Place of keeping, very important. You will by default keep it at the registered office address. Sir, can I keep it any other place? Absolutely possible. You can keep it any other place in India by just passing a board resolution. Books of other place in India as board of directors may decide. Provided within 7 days, people, you need to inform ROC, inform AOC file about the new location. That is one important part. And people, audit trail, important. That off late we are seeing questions coming here. What is audit trail, people? Can I maintain my books of accounts in electronic form? Yes, people, possible. People, remember, from first day of April 2023 onwards, if you guys are maintaining your accounts or books of accounts in electronic form, you have to use such softwares which mandatorily has audit trail feature. Imagine if I'm using Zoho, it should mandatorily have audit trail feature in it. But what do you mean by that, people? Nothing but imagine if someone has edited some particular accounts, that system should be able to capture it. So if that feature is there, then we don't mind. If not, you cannot use it. Yes, meaning any changes are made, all that the system we should be able to capture it. That is audit trail. Okay, and books of accounts, the branch office, it will be kept maintained in the branch office only. It will be sent once in 3 months. We will prepare a quarterly summarized returns will be sent to the head office. The head office will consolidate it. Okay. Inspection by directors. They can ask you a question here. Can any direct inspect this particular books, sir? Any director can inspect the books of accounts and other books, papers of the company during the business hours. Sir, can we inspect the books of accounts of our subsidiary company? Yes, provided there is an authorization by the board of directors. And remember, whatever is the request, all assistance in connection with the inspection, meaning the employees have to make sure they help you. Sir, what if the books are maintained outside India? The director himself personally should request for it, and the company has to give it within 15 days. You cannot use any advocate or an agent to ask for the documents maintained outside India. Period of preservation of books, people, it should be maintained for a period of 8 years preceding the current financial year, meaning in the year 25-26. If I'm calculating for how many years I have to maintain my books of accounts, leave this, go back 8 years, up to 8 years you have to maintain. But if central government has ordered that you have to maintain for a higher period, for your company, you will maintain for a higher period. Correct? People responsible for maintaining books of accounts, managing director, whole-time director in charge of finance, CFO, or any other person authorized by the board. This is what I told you in office or in default. Remember, these are important. They can ask you, who are the people responsible for maintaining books of accounts? MD, whole-time director in charge of finance, CFO, or any other person authorized by the board. Okay. Yes, place audit person responsible. Exemption from CFS, consolidated financial statements. Correct? What is consolidated financial statements? It is given in page number 9.6. Okay, consolidated financial statements means, people, I have to join my subsidiary companies, associate companies ka complete details, and I have to present in my AGM in front of my shareholders. But sir, is it applicable for every company? Yes, sir. That along with my company, I will join my subsidiary companies, I will join my associate companies ka financials also. Is it applicable for everyone as well? People, section 129, you have an exception. What is that? If it is a wholly owned subsidiary, or if it's a partially owned subsidiary of another company, and all its other members, including those not otherwise entitled to vote, have been intimated they do not object to the company not presenting CFS. What do you mean by that, sir? Company A, there is company B. Company A holds 55%. Rest of the 45% is with someone else. Sir, all of them say, we don't mind if you do not do a CFS, we don't have any issue. If we give that declaration, then we don't have a problem. Or if you are an unlisted company, or you should not be in the process of listing on any stock exchange, whether you are in India or outside India. So for you, it's okay, we do not demand this. The third one, its ultimate or intermediate holding company has already filed. Meaning there is company A, company B, there is company C. So let us imagine company A has already filed for company B and company C. Now company B again need not file it for company C. No, that is what is the third condition. They can ask you, remember and go, important. Clear? That is CFS. Company is covered under NAFRA. Company is covered under NAFRA, important. 9.11. 9.11. 9.11. I hope you guys are understanding that. De macha. Okay. Sir, NAFRA, your National Financial Reporting Authority, they will oversee the quality of the professionals, and they will also monitor. If they will also suggest you any feedback and all, if required, they will suggest you and you need to follow it accordingly. Companies whose securities are listed on any stock exchange in India or outside India, for them NAFRA will apply. Meaning what, people? Whoever are the auditors who are auditing these companies, NAFRA will come and say, Macha, show me your work. I will need to see whether you are auditing these books properly or not. Who are those companies? Any companies who is listed on stock exchanges, whether in India or outside India, for you. Unlisted public company having a paid up capital of not less than 500 crore, annual turnover 1000 crore, aggregate of outstanding loan, debentures and all 500 crore. For them, yes, it will be applicable. Insurance, banking, electricity and companies governed under any special act applicable. Any body, corporate or company or persons or any class of body, corporate or company or persons on a reference made to NAFRA by CG in public interest. Meaning what, sir? Central government will say, hey, going for a NAFRA, you include LLPs also. We will start including LLPs also. Currently, we have not yet done, but we can add to this list. Next one, a body, corporate, incorporated or registered outside India, which is a subsidiary or associate company of any company, or a body, corporate, incorporated or registered in India, as referred to in A to D. A to D is what, people? A to D. Sir, A to D, a body, corporate, incorporated or registered outside India, which is a subsidiary or associate of any company. Meaning our A to D is there, no. If their subsidiary or if their associate, if it is incorporated outside India, this is outside India. And if the income or net worth of such subsidiary or associate exceeds 20% of the consolidated income. So if I take my company and subsidiary company, if I take consolidated income, the subsidiary company is giving me 20% of my income. Then they are telling you, even for this company, subsidiary or associate outside India, for them also this NAFRA rule will apply. That was an important point, remember. Authentication of financial statements. Who will sign the financial statements? Important, remember and go. The chairperson, if at all it is authorized by the board, the chairperson will sign it. If not, sir, it will be two directors. And if a company has a managing director, then managing director shall sign it. This is very, very important. They will ask you, sir, if your company has a CFO, CEO, CS, all of them has to sign. If all three are there, everyone will sign. So in case of OPC, one director signature is sufficient. So chairperson or two directors. If managing director, then managing director. CEO, CFO and CS if appointed. Correct? Okay. Next one, sir. Director responsibility statement, people. What is that? Whenever you are following your accounts, sir, you should give a declaration that, sir, I have followed all the best practices. I do not have any non-compliances. I just have to give a declaration. So annual accounts were prepared as per the proper accounting standards. If at all I have not followed accounting standards, then what should I do? I have to give a deviation. I have to give the reason for the deviation. What is the benefit I made? And meaning what is the financial benefit and reasons for such deviation. And what is the deviation? Nature of the deviation. I have to give it in my board's report. The directors have selected proper accounting policies which will give the true and fair view. The company has maintained proper accounting records. We have maintained the books as per going concern basis. Our company has proper internal financial controls which will stop fraud and all that. CC cameras and all properly are there. And the proper systems to ensure compliance with various laws applicable. For a company, there will be so many laws applicable. What system you have which will ensure that you are following with every law? What system you have? That is what you need to give here. Correct? Sir, who will sign the board's report? Chairperson, where he is not so authorized. It should be signed by two directors and managing director, or the director where there is only one director. That is nothing but in the case of OPC. CSR, people, remember, I've made a complete video on CSR. People, try to watch it because it's a very huge thing. I should end up literally explain the entire thing. I've also done it in the marathon as well. But CSR, there is a whole topic that I have uploaded. Please try to watch that. Important, you wouldn't mind watching it is what I would say. XBRL, sir, on which companies XBRLs are applicable, people? Again, some important point. Try to see. Okay, the following class of companies shall file their financial statements with the registrar in AOC for XBRL, whichever is a company listed, and all their Indian subsidiaries. Foreign Allah, macha, here a question can come. Pakka. Companies having a paid up capital of 5 crore or more. See here, companies. We are not saying it is public or unlisted or listed, nothing. Companies, private company also applicable. A company having a turnover of 100 crore or more. All companies which are required to prepare their accounts as per Ind AS. They need to make sure they follow XBRL. And remember, once an XBRL, always an XBRL. But this condition will not apply to a few companies. NBFC, HFC and companies engaged in banking and insurance sectors. For these people, this will not apply. They can ask you this exception part also. Always pay attention to the name of the company in the question. That is very, very important. Is clear? Hello? Okay, done. Unadopted financials. Sir, now every company has to file Form AOC4 within 30 days of AGM or due date of the AGM. Sir, what if in my company in the AGM we were not able to adopt the financials, meaning the shareholders have not said yes to it? In such case, you have to file such unadopted financials only with ROC. ROC will consider such financials as provisional. Once the financials are accepted, you have to again file it, which ROC will consider as a permanent one. Sir, what if in my company we never conducted the AGM at all? Then in such case, people, such a financials which is not yet adopted, because of course AGM is not conducted, you will directly file that only, people. And along with that, you have to give reason why we were not able to conduct the AGM. You have to disclose this to ROC. They will ask you most of the times. This chances is always there. So remember this and go. Is this clear, all of you? So that's one thing I thought it's a peculiar point. Next one, sir, internal audit. Important again. Sir, what is an internal audit? Having a one complete audit team which is doing an ongoing basis, checking everything concurrently. Every day is called as internal audit. One thing I always say, DPLT, Deepika Padukone, work for L&T. Deposits, paid up share capital, loan, turnover, 25 into 2, 50, 50 into 2, 100, 100 into 2, 200. Deepika Padukone work for L&T. So 25, 50, 100 and 200. Remember this and go. Sir, wherever the star mark is there, that is important. What is the importance of star mark? During the preceding financial year, we need to check as per preceding financial year. Wherever there are 2 star marks, the 2 star marks are the bomb. What does that mean? Sir, in the previous year, even one day, we had a, let us imagine, loan of 100 crore. Even one day we had it. In such case, people, we need to make sure internal audit is applicable for us. Even if one day it is there, we need to make sure it is applicable for us. So remember that. So meaning what? In the beginning it was 100. During the year end it has become 95. Is it applicable to us? Yes, it is applicable. And who can undertake a internal audit? It can be a chartered accountant, cost accountant, or it can be any other professional. It is possible. And that person can be an individual. It can be even a partnership firm also. It can be a body corporate, meaning even LLP also can be appointed. People, just for your information, PwC was the internal auditor of Satyam. So internal auditor need not be individual always. Even someone else also is possible. Of course possible. Is clear, all of you? Pakkana? That is your internal audit. Remember and go. Next one, people, audit chapter. Macha, rotation of auditor and all the rules. So rotation of auditor, try to follow. In the auditors chapter, of course I am not going with appointment and all. Just directly go with the rotation, because nowadays they have not asked this appointment. But remember, in the case of government company, it's always CAG that appoints the auditor, and it is done always every year. Correct? Okay. Removal, resignation of auditor and giving of special notice. Which is that? Okay, where is this? Yes, sir. The rotation of auditors, sir, meaning one auditor cannot continue with the company forever. You have some maximum tenure. The maximum tenure will be applicable only for some companies, which are that if you are a listed company, rotation will be applicable. Unlisted public company having paid up capital of 10 crore or more, all private companies having paid up share capital of 50 crore or more, all the companies having the aggregate of bank deposits, public deposits, public financial institutions, loans and all of 50 crore or more, for them the rotation will be applicable. What do you mean by rotation? If you are an individual auditor, then the maximum tenure can be 5 years. Can I reappoint him? No, not possible. I need to have a cool off period of 5 years. Sir, what if I am an audit firm? I can appoint you for 5 years of 2 tenures. Correct? Yes, sir. Okay. That is what it is. Okay. And what else? What else? What else? What else? What else? Government company, it is always them only who will appoint. Removal and resignation. Can we remove an auditor, people? Always remember, I need to take shareholders approval plus central government approval mandatory. Resignation, people, yes possible. The auditor will have to submit the resignation to ROC, to the company, as well as to SEBI if the company is listed. So remember that. Auditor acts in a fraudulent way. Remember, if central government feels that a particular auditor is acting in a fraudulent way and they complain it to the tribunal, such person will be removed and he cannot be reappointed for a period of 5 years. He can be completely debarred, and CG will only appoint another auditor for such companies. Disqualification of auditors, people who cannot be an auditor. Who cannot be an auditor? Disqualifications are. A body corporate, LLP is possible. Company, definitely not possible. An officer or employee of the company. If you are an officer or employee of the company, you cannot be appointed as an auditor. A person who is a partner or who is in the employment of officer or an employee of the company. A person who is a partner, meaning what, sir? In my company, we are planning to appoint an auditor in Reliance. In my company, there is an employee or there is some officer. Sir, if they have a partnership, sir, or they have their own company, in this partnership, if there is any partner, sir, in this company, if there is any employee, we cannot appoint this employee as an auditor in the Reliance. I cannot appoint this partner as an auditor in this Reliance. A person who or his relative or partner, people, an auditor cannot hold even one share. But sir, what if it is relatives? Relatives, yes, possible, people, they can hold up to 1 lakh rupees. But remember, it is all the relatives put together. It is using interpretation of statutes that your company, the institute has given that. Indebted to the company, that is a person who has taken loan from company, subsidiary, holding or associate in excess of 5 lakh. Up to 5 lakh is allowed. Up to 1 lakh was allowed. Guarantee up to 1 lakh is allowed. A person or a firm who whether directly has business relationship with company other than ordinary course of business. Meaning what, people? Meaning I'm an auditor of Zomato. I will also order food. Like the way they give food to you, they will give it to me also in the same way. Provided that order should be treated at arm's length price. However, we treat a normal customer, we have to treat our auditor also in the same way. Then it is okay, it is allowed. A person whose relative is a director or is the employment of a company as a director or KMP. People, a person whose relative is a director or is in the employment of a company as a director or KMP. Remember, if you are a normal employee, then it is okay. You should not be a director or KMP. Whose relative is a director or KMP only is the problem. Employee is okay. Imagine if, a person, now my brother is a software engineer. Can I be appointed as an auditor? Yes, possible. I'm saying if CA and all, yes, possible. If such person or partner is the date of such appointment or reappointment, the maximum audit assignments you can take up as people, 20, not more than that. But remember, in the 20, you should not count dormant company, OPC, small companies and private companies having paid up capital less than 100 crore. Don't count them. Excluding that, you can have maximum as 20. Sir, and one more thing, sir. The auditor shall not give certain services. And what are the services, people? We need to see what are the services that the auditor cannot give. Section 144. So if I'm already an auditor of your company, I cannot do your bookkeeping, accounting services also. I cannot do your internal audit. Because it's like, people, imagine I give you an exam, you will only evaluate. You all will get 150 on 100. Correct, no? Actuarial, meaning risk assessment services, investment advisory. Sir, invest in Infi, invest in Bajaj Finance, investment banking services. Imagine mergers, amalgamations and all that. Rendering out of outsourced financial services. Imagine GST filings, HR department, payroll, management services. Imagine something like management information system, any other kind of services as may prescribe. If you're doing this already to the company, you cannot be their auditor. Or if you're there already an auditor, you cannot do these services to the company. Correct, or disqualification of auditors. Foreign company definitions. Okay, this is important. Foreign company definition 11.1. Yeah, I hope it is making some sense. Yeah, I've just taken all the possible thing. I was just preparing it and I thought it will help you guys. So definition, people, what is a foreign company? People, this is where maximum chances, people. It means a company or body corporate incorporated outside India. Incorporate outside India, which has a place of business in India. Meaning you should have a place of business in India. That business can be done by you or through an agent, physically or through an electronic mode. And meaning everything, all three should be satisfied. Incorporated outside India, you should have a place of business in India, whether personally, agent, electronically, or conducts any business activity in India in any other manner. So sir, you have to conduct business also in India. People, remember, registrar and share transfer agent is also considered as place of business in India only. So such companies are called as foreign companies. 242, correct? Okay, next one, sir. Application of act to the foreign companies. People, for the foreign companies, people, this particular chapter will apply. But however, remember, where not less than 50% of the paid up share capital, whether equity or preference, or partly equity, partly preference of a foreign company. Imagine I'm talking about a company in US, incorporate outside India. Let us imagine Google. Sir, in this, at least 50% of equity or preference is held by one or more citizens of India. Indians are holding it. Or one or more companies, Indian companies, or Indian companies and citizens. Then people, they're telling you this chapter and such other provisions of this act as may be prescribed with regard to the business carried on by it in India as if it were a company incorporated in India. Meaning what, people? I can treat you as if you are a company incorporated in India. I can tell you to comply literally with all the provisions if I need, just like an Indian company. This is also important. They can ask you one more thing. They will ask you is whenever a company is coming to India and what are the documents you need to deliver to ROC. First one, the certified copy of charters, meaning MOA, AOA of your principal office, that is USA. The full address of registered or principal office of the company, USA. The list of directors and secretary of the company, USA. In relation to the nature particulars above, I need to give all these details, their passport number, personal details and all that. Okay. The name and address of one or more person resident in India. This is very, very important. This is the person to whom we give notices to. One person representing the foreign company in India. We have to give such representatives details. If we have any problem tomorrow, the notice given to this person is as if it is given to the foreign company. The full address of the office of the company in India, which is deemed to be the principal place, meaning the address in India. All of this we have to file it with ROC, New Delhi. Particulars of opening and closing of the place of business in India in the earlier occasion. In the past, have we come and gone? In which form we will file all of this? We will file it within FC1. You have to file it within 30 days of you establishing a business in India. Declaration that none of the directors of the company or the authorized representative, that is, you are nominating one person in India, no, that none of them should have been convicted. In one attempt, they have asked a question, what if the secretary is convicted? Here you have given secretary details also, no. Remember, secretary's information is not given here. So even if a secretary is debarred, you can still go and file a the FC1, it is allowed. There is no prohibition. It will be filed in form FC1 within 30 days. These are the things I felt was very important. So see and go. Chapter 12 LLP. So people here remember minimum partners, same thing. 2 partners, less than that people 6 months, the same condition will apply. Designated partner, there shall be at least 2 designated partners. One of them shall be resident in India. But remember, the resident here means a person should have stayed at least for a period of 120 days during the financial year. If it's OPC, previous financial year. Correct? And what is this? Small LLP. Small LLP is nothing but 25 lakh and 45 lakh. Correct? Small LLP. Small LLP, small LLP. Where are you, small LLP? Yes, 25 lakh and 40 lakh, small LLP. Correct. Financial year people, same logic. Up to 30th September, you will consider it as a previous year. Imagine if it is 30th September 2024. My financial year will end on 31st March 2025. If at all my year of incorporation, my date of incorporation is 1st October 2024. My date of my financial year will end on 31st March 2026. Same copy paste logic that we saw in Companies Act. Statement to be filed during financial year. Remember people, what is the statement to be filed during incorporation? A CA or a CS or a CMA or an advocate along with the partner. We have to say that whatever are the rules that we need to comply with, we have complied with all the rules, sir. There is absolutely no non-compliance. We have to give a declaration. People, LLP, I would say, ratta marke go. You have to know everything in LLP, people. The reason I'll tell you why. Because you can expect anywhere between 7 to 9 marks pakka from LLP. MCQ, there can be 2 marks into 2 possibility. 5 marks question, one can come, 5 to 4 in addition in descriptive. So remember, important. Rectification of name, cut copy paste that we saw in Companies Act. Consequence of secession, people. What is that? Remember, if a partner dies, will the LLP come to an end? No, LLP will still continue. Nominees will come into picture. However, remember, the nominees will not enjoy the same right. They do not have any right to interfere in the management of the company. Same right will come in assignment. Assignment means what? One partner transfers his share to an outsider. The outsider will not get the same treatment as the existing partners. You cannot interfere in the management of the affairs of the business. Important, they can ask you a question. Sir, extent and limitation. In this, 2 important concept is concept of whistleblowing and holding out. What is whistleblowing? Whenever any employee helps us or any partner helps us in disclosing any information, and if that results into prosecution, that is everything he discloses, then the tribunal enjoys the right of waiving of the penalty or even reduction in the penalty. Both are possible. Correct? That is whistleblower policy. And remember, we try to make sure that you are safeguarded, you are not removed, you are not demoted, you are not taken away from your job. All that we will take care. Next one is called as doctrine of holding out. What is doctrine of holding out? Whenever the partners allow a random person to represent to the world, A, B are a partner, C is representing to the world that he is a partner, and A, B is silent about it, then macha, you should shut your mouth forever. When he is telling you are keeping quiet, then for that third parties to whomsoever he has represented in your presence, for all of them you will be continued to be liable. You will be treated as if you are a partner with them. So any profit you have to give him a share, any loss he will also be accountable. Correct? Okay, next one, people, financial disclosure. Nothing but people, every company shall maintain statement of accounts and solvency within 6 months of closure of financial year. They have to maintain statements of accounts and solvency. They have to prepare statements of accounts and solvency within 6 months. They have to file it with ROC within 30 days of completion of 6 months. and a company has to maintain annual return. It has to file it with ROC within 60 days of closure of financial year. Remember, that is your financial disclosure, important. Compounding of offenses, people. Remember, I have done some mistake for which only the fine is there, no imprisonment. Such offenses can be compounded, meaning I'll go and accept my mistake. Yes, people, once I accept the mistake, then people, whatever is a penalty, they can say, imagine minimum is there, maximum is there. There are chances that people, there will be no maximum penalty, but in compounding, the penalty cannot go less than minimum. If Act says minimum is 1 lakh, less than that it cannot go. 1 lakh at least will be collected from you. Sir, can I keep doing compounding every year? Sir, no, people. Once you compounded anything this year for same offense, from the date of compounding, for the next 3 years, you cannot compound the same offense again. Sir, after 3 years, people, it will be considered as if it's your still first offense. You can still go ahead and compound. Possible. Correct? That is assignment. That is another. People, general clauses, IOS, randomly they'll pick off everything. I cannot say that this is important and this is important. Yeah, that is not possible. Very, very difficult for me to tell. People, this FEMA part alone, make sure you guys watch the residential status. What is residential status, people? What is the main thing here? So, whenever a person would have stayed in the previous year for more than 182 days, and if a person has come to India for those 3 purposes, and if the person has gone out of India for those 3 purposes, you need to keep that in mind. If at all that is kept in mind, you can almost answer FEMA. Correct? That is the main thing, if you guys know, if you guys remember. But one thing with for me, FEMA and all will take time to explain. But I have done that completely in detail in marathon. What I would suggest is this alone. I have marked the important points. See if you guys can go through once. Because I do not want to just... I'll see how much ever I can do it. But yes, just remember. So people, if a person has stayed for more than 182 days in the previous financial year and during the current year, if the person has gone out of India for any of these 3 purposes, that person is excluded for the current year. He will not be a PRI. What is that? If he has gone out for employment, if he has gone out for business or occasion or any other purpose, the period of stay is uncertain. If you have gone out for this, you are not a PRI. You will be considered as PROI. Sir, what if I go for a vacation? Does it come under any of these 3? Occasional, vacation, trip. It will not come under these 3. So in my previous year, if I have satisfied 183 days condition, meaning more than 182 days, and in this year, if I have gone outside India for trip, for the current year, I will still be considered as PRI only. Same thing, if a person who has come into India for anything other than these 3, meaning taking up employment, carrying on occasion, in short, a person who comes to India for any reason other than mentioned above, he shall be considered as PROI. If he comes for the above mentioned, he will be considered as PRI. Meaning what? If he is coming for employment, he is PRI. He is coming for business or occasion, he is PRI. He is coming for any other purpose, period is uncertain, he is considered as PRI. Sir, what if he is coming for a trip? PROI. Sir, what if a person in the previous year has not stayed in India at all, 0 days, but in the current year he is coming for employment? Is this person a PRI or PROI? He is coming to India for employment. People, he is a PRI. Because definition is given that if a person has come to India for this, he is a PRI. So do not look at 182 days condition there. He will be a PRI. Is this clear? Okay, done. And so another thing is current account transaction. So make sure you guys see this current account transaction. There is something called as schedule 1. We have something called as prohibited transactions. This list is a prohibited accounting transactions. So there is a huge list. For me, instead of just repeating what I felt was this part, I'll give you a list. See if you guys can watch the marathon. Hardly I've done it within 2 hours or something. 1.5 to 2 hours complete other laws. It will definitely help you guys. Try to watch it. For this alone, I'll just give you the list because it's a huge thing. It will again take 2 hours. It will become marathon only. I don't find reason to do marathon again. I know you guys want this document. I'll upload it to you guys. I'll give you a link to download. You guys can download. So that's it for today's thing. We'll again catch up for RTPs. I will try to do as many RTPs tomorrow's session, and then it will be MTPs. And finally, people remember, I will be telling you on how to present your answers. I will make sure your answers are properly presented. Let us practice writing some 20 questions. I'll tell you where an examiner sees a particular mistake and there is no mistake and all. Let us try to analyze and let us improvise our presentation in law. So that is going to be our next 3 days plan. RTP, MTP and presentations. Clear, people? Thank you so much. I hope this video served some purpose. So I'll be the most happiest person if at all you let me know if this helped you, and if your results really go good, I'll be the happiest person to enjoy this result with you. So thank you so much. Wish you guys all the best. Bye bye.